Lordship.
Yes.
I beg to mention for listing on admission matter, my lord.
When?
Next week, my lord, Wednesday.
Wednesday, there will be some, it's a holiday.
Ah.
19th we'll have.
19. Obvious.
Lordship, I beg to mention item 46, Lordship. Item 46, Lordship. For orders.
Yes.
Lordship, the matter become infectious, Lordship.
You are Mr.
M.S. Alam.
M.
M.S. Alam.
Mr. M.S. Alam and the counsel for petitioner. They have complied.
Yes, Lordship.
That means that the respondents have complied with the order passed by this court. And therefore the matter has become infectious. Accordingly, this contempt petition is closed. Yes.
Yes, Lordship.
So item number 22, 23, and 24, my lord. My lord, I already informed my lord. Matter is taken up, my lord, next week, man.
You are for petition
I am the petitioner, my lord. Contextual matter, my lord.
on request made by N. Boral and the counsel for the petitioner. List the matter when? After a week?
After it.
After 1 week.
What's
May it please the Lordship. My lord, I beg to mention this matter for listing for admission, my lord. This matter relates to promotion, my lord. We filed it on 2022 and the respondents have also filed an affidavit. And the urgency is this, my lord, in March, my lord, the new promotional process is going to be started, my lord. So any date convenient to Lordship, my lord, before March.
21st?
Deeply obliged.
May please, Your Lordship, I pray for listing a writ petition, my Lordship. Kindly leave this matter next week, 13 or 15 any day.
15 and 16 there will be some difficulty. We'll have it on 19th.
Okay,
Yeah.
okay, my Lordship, Vice Minister.
May I please, Your Lordship?
Mm.
I beg to mention item number 43, Lordship. Your Lordship, may kindly adjourn this matter for today, Lordship. As my senior is after station, Lordship. I have taken
Who's-
consent from the other side.
Who's your senior?
B, Your Lordship.
On request made on behalf of B. Buyan, learn a counsel for the petition and list after 1 week.
Please, Lordship, within continue, I beg to mention item number 14, Lordship. It may- 14, 1-4.
1-4.
It
Yes.
may be adjourned for today, Lordship.
Okay. On request made on behalf of
PK Roy 30.
PK Roy Jodri, learn a counsel for the petitioner. List after 1 week. Yeah.
May I please, Lordship? I beg to mention item number 15, Lordship,
Mm.
on behalf of BK Gogoi. Kindly adjourn the matter for today, Lordship.
Okay, on request made on behalf of Mr. B.K. Gogoi, learn a counsel for petitioner. After 1 week. Yes.
Mm.
I beg to mention for item number 18, madam. This is a FT matter, madam. This
Hmm.
matter may be listed in the appropriate format,
Item 18 is AFT matter.
madam.
Okay, list this matter before the appropriate bench.
Review.
May I please, Your Lordship? Your Lordship, I beg to mention item number 13 with the consent of the other side.
Mm.
Your Lordship, I am appearing on behalf of Mr. R. Hussain. Your Lordship, the matter may be adjourned for the day.
Okay, on request made on behalf of R. Hussain, learn a counsel for the petitioner.
It
After,
may be listed after 2 weeks, Your
after
Lordship.
2 weeks.
My lord, let date may fix, my lord, 29th of my lord, February.
Okay, 29th.
My name will be accurate, my lord.
Mr. S.K. Medi, learn a CGC appears for the respondents.
May I please, Your Lordship? I would like to, item number 30, adjourn for today, my Lordship,
3-0.
for the petitioner.
3-0.
30.
3-0.
30.
When do you want?
After 2 weeks, my Lordship,
Okay, your good name?
Eldas,
Year for day?
petitioner.
Okay, on
We have
request
the
made
consent of
on
the side.
behalf made by MS Eldas. Learn a counsel for petitioner. List the matter after
2 weeks.
2 weeks.
Blessed.
May I please, Your Lordship? Lordship, I beg to mention item number 41.
Lordship, matter may be adjourned for today. Lordship, we have informed the other side.
You are appearing for
Mr. J. Roy.
on request made on behalf of Mr.
Lordship,
J.
matter may be fixed, Lordship, on 26.
Then counsel for the petitioner, list the matter on 26.
Obliged.
May I please, Lordship? And Lordship, I will beg, I'm beg to mention item number 20. With the consent of the opposite party, I am for the petitioner, Lordship. With the consent of the opposite party, I am praying for adjournment for 4 weeks, Lordship, to file the reply affidavit.
Your Lordship, I'm for the item number 2.
Okay. Your good name?
Armali. Lordship Armali.
You are appearing on behalf of
On behalf of G. Rahul and GM Nat.
on request made on behalf of J. Rahul, then counsel for the petitioner. List after 4 weeks. Okay.
Obliged, Lordship.
May please your Lordship.
Mm.
Lordship, I beg to mention for listing of a matter in the next week, Lordship.
21st.
21st, Lordship. Obliged.
May please. I mention item 11. It's a part third matter. It was fixed for 9/11/2023. Arguing counsel G. Goswami has some difficulties today, Lordship. Lordship, if kindly accommodates for today.
P.K. Goswami.
G. Goswami.
Okay, on request made by Mr. B.B. Bora. List the matter after.
Lordship, next week, any day, 13th, Lordship, next Tuesday.
Next Tuesday, difficulty is there? Some difficulty. We'll
Yes,
have it on 20.
Yes.
20.
Item 2 for motion.
May I please, Lordship? My Lord, in terms of earlier order, I have already filed an additional affidavit, Lordship, bringing on record certain documents, Lordship.
Where's your additional affidavit?
Lordship, that is page, Lordship, 37 onwards. Only to bring you on the
1 minute.
bring you on record, Lordship, on
Huh? Oh.
Where's the letter?
Lordship, letter is page 40.
Lordship.
Hmm.
Limited issue, more dispose of
No, এটা কোথায় টেকনিক্যাল ইস্যু তো আছে কইতাম
আপনি কবে হইতো বিষয়?
ঠিক আছে
Well, the process has already been initiated by the executive engineer. Well, today, Lordship, I have a limited prayer, Lordship, let the matter be disposed of, directing the executive engineer PAC to take a final decision, considering the grievances of the petitioner. And if necessary, Lordship, petitioner and the private respondent number 7 may be directed to take part in the hearing also, Lordship.
Lordship,
Regarding, Lordship, a caretaker in a Jolajibon house, Lordship, that has been constructed on the land of the petitioner. In fact, the land was a government land. Lordship. I possess the land and purchase the same from other person. Now, Lordship, the project has been made. The son of the person who has already sold out the land is projected to be engaged as caretaker. The Lordship may dispose of this matter, directing the executive engineer to take a final call, considering the grievances of the petition, instead of keeping the matter pending, because of this pendency, Lordship, nobody
Yes,
is
sir.
engaged.
yes, Lordship, in paragraph 3, Lordship, page number 38, Lordship, it is categorically stated, Lordship, in his affidavit, Lordship, additional affidavit, Lordship. It is stated that the Zolmitro, the land owner has in first right to prefer, and accordingly, the BDO has been instructed to complete the selection procedure for Zolmitro as per the SOP by conducting Gram Sabha, Lordship. Now the Gram Sabha organized by the BDO, Lordship. BDO belongs to the PNRD department, and PNRD department is not called by the petitioner here in this case, Lordship. PNRD is not the party here.
Who is the PNRD?
Yes, PNRD is the,
Video.
yes, BDO. BDO is the BDO belongs to the PNRD department, Lordship. And the PNRD department is not not called by the petitioner, Lordship. He is not the party here, Lordship.
He may not be
No, no, it's
necessary
effective,
party. In fact,
effective
Lordship,
necessary party
this
because entire process will done by the BDO, Lordship. As per his affidavit, Lordship. It is paragraph 3, Lordship. It is categorically stated, Lordship, that the Jolmitro, the landowner has in first
Well-
right 38, Lordship. Page 38, paragraph 3, Lordship. Lordship, got it, Lordship.
in my additional affidavit.
Yes, in the additional affidavit of the petitioner, Lordship.
Yes.
Yes, his grievances is for the selection, Lordship. The selection will done by the BDO, Lordship. BDO is not the party here, Lordship.
Then you make him
Yes,
a party.
Not, in fact, he will Lordship direct the executive engineer, Lordship. He will
How
take
can the
that.
executive engineer?
He will
Lordship,
take all
what
his
is the
steps, Lordship.
committee?
So executive engineer has written to the BDO.
Yes, Lordship.
All right.
My lord.
Now BDO has to take steps.
Exactly, Lordship.
So let the BDO be party and then we'll pass the orders. You file an IA immediately.
My lord. Lordship.
How much time you require?
My lord, 1 week time.
Mr. M. Khan, London Council for the petition. Please for a week's time to enable him to file an IA for implementation of necessary parties.
Right.
List the matter after 1 week.
Bless.
Item 3.
May I please, your lordship? May I please, your lordship?
Yes.
Matter relates to compassionate appointment of the petitioner. She was found to be eligible by the SLC, but did not was not appointed for lack of vacancy. The order is at page 21, lordship. The minutes will be at page 20 of the SLC, where they have stated that they have found 7 candidates to be eligible. However, there is no vacancy. That is why they are not appointed. The order is at page 21. The petitioner name is Srimati Kansan Basumata, Lord. She was recommended way back in 2016 by the district level committee, state level considered in 2019. And she was never been informed, though if lordship sees below the copy to number 2, the director was directed to inform the petitioner. She was never been informed about her rejection. She only came to know in 2023 end when one of the candidate, Srimati Namita Das, who is named in the same order, was
Lordship, now it is 10 years, Lordship. What is the necessities, Lordship? At this stage, Lordship, it is after passing out the 10 years, Lordship. What is the necessities, Lordship? That is the question here in this case, Lordship. Lots of cases, Lordship, with the Supreme
Lordship,
Court
only point-
directed that. Just a minute. Supreme Court directed, Lordship, that the necessary it is for the immediate necessity. It is not the right, and it is the immediate necessities of the legal heirs of the deceased, Lordship. But here in this case, Lordship, after passing 10 years, Lordship, what will be the necessities, Lordship, at this stage, Lordship? And moreover, Lordship, in the petition, entire petition, Lordship, there is no reflection about the necessities at this stage, Lordship. It is not the stage of the application, Lordship. But now it is after 10 years, Lordship. What is the necessities at this stage, Lordship, that is not defined, Lordship.
Lordship, how the delay has occurred. 2014,
Delay is the separate way, Lordship. But the Supreme Court.
Lordship, 2014 I applied immediately after my father passed away. After 2 years in 2016, DLC considers send it to the SLC. SLC considered in 2019, rejects in 2019. There's a specific direction in the order to intimate the petitioner with regard to her cancellation, which has not been done. She only came to know one of the candidate who was
With the SLC minutes,
page 20, Lordship.
20.
20. 1 page prior to the order, Lordship. If Lordship sees the paragraph number 3, Then the vacancy position proposal submitted by Director Town Planning. It was informed that there are 8 compassionate ground posts at 5%, and since 5 have already been appointed, only 3 vacancies are left to be filled up as per so and so. The committee noted names of 7 candidates. One of is the petitioner, Lordship. They found it to be eligible in 2019, but did not appoint for lack of vacancies. Whereas the extent policy says the vacancy can be adjusted any other department, which was not done, Lordship.
But 2019.
Lordship, it was, if Lordship sees page 21, point number 2 below, page 21, Lordship. Below the copy 2. Next
That
page.
I've seen. That I've seen.
I was not informed at all, Lordship. Let them come up with the instruction. If they have informed me, then I probably will not have a case. But they have not informed for last
No,
5.
whether you are informed or not, you have already crossed more than 10 years.
Lordship,
Now
I'm
you
still in the
will-
hardship. The question
Yes.
is, it's a compassionate appointment, Lordship. And it is only for the delay on the part of respondent. We have, on my part, I have done what was supposed to be done at 2014. The application has to be considered by the district level committee and the state level committee, and rejection has to be intimated to the petitioner, which was not done, though there is a direction on the order itself.
Rejection was done in 2019.
19, Lordship. I came to know only in 2013 when one of the applicant whose name was rejected was appointed on the strength of an order of this honorable court, Lordship, in 2023. Only then I came to know that we are rejected at that point of time. Otherwise, no intimation. And the petitioner belongs to a very remote place, Lordship. And there is no. Let them come up with the instruction, Lordship. That
No, Lordship.
Not required.
No,
Lordship, but
instruction is not required. The
but the
principle of the compassionate appointment is that, Lordship, it is the necessity, immediate necessity, Lordship. That was clarified by the honorable.
Lordship, the necessity if exists.
No, Lordship. There is no.
The question remains, I was not even intimated since 2019, though there is a direction on the part of the department to intimate. And I had no option to go and find out. I'm from a very remote family and also a remote place, Lordship. Let them come up with instruction. If they have informed me, then probably I'll not have a case.
No.
And if they have not informed me, then my rejections stood in 2019.
This case is.
Rejection is of 2019.
Lordship, but
Yes.
I was not informed, though there is a direction on the part of the.
That is a different thing. Now it's more than
Lordship,
more
that
than
is
10
correct.
years after your father died.
But the situation still persists, Lordship. So my prayer would be, let them consider it is a compassionate appointment. It is. Let them consider once again if they found to be eligible, finding out.
Sorry. Cannot. Your only ground is that you were not informed.
Also,
No,
Lordship,
no,
no. Also,
see-
second ground is that they cannot reject on the point that there is no vacancy. Lordship sees
That
the.
is too late in the day now.
Lordship, that's true, but the delay
That
has
is
been
too late
caused
in
not
the
by the
day.
latches on the part of the petitioner. It is only because I was not intimate. And though there is a direction, Lordship, had there been no direction to intimate the petitioner, probably petitioner would have latches and but there's direction on the part of director. The response number 3 was ought to page number 21, Lordship, point number 2. The director, Municipal Administrative Assam Dispute, is requested to inform Srimati Kansan Basumatar and Namita Das, and I was not informed. Lord. Let them come up with instruction. If they have informed, then I will not have a case. I will not pursue it. Not even notice.
This is the
Let them come
question
up
of maintainability of this petition, Lordship. Yes.
Nothing survives here. I'll dispose it.
Let them consider, Lordship, on the next level. If at all she is eligible, she will be only to consideration. Will not give a
That
right.
constitution was done. That constitution was done.
She was found to be eligible. Only rejected on not being vacancy.
Not vacancy, but that
But
is too-
eligible in 2019
Too,
will.
too late in the day. Now you are challenging a 2019 order today.
Lordship, the delay has, as apparent, Lordship, delay is, though there is a direction to intimate the petitioner, there is no intimation to the petitioner. Let them come up with the instruction, say that the petitioner was intimated about the rejection, Lordship.
There's no point.
And Lordship, the rejection itself is dehours the policy, which is That the vacancies has to be considered to be the other department also, Lord.
That is there, that is there.
But that I
If
missed
you
out,
have challenged it at the right time,
Lordship, I missed out the chance to challenge this because I was not
if
intimated.
you've challenged it at the right time, then
Of course, Lordship.
you
That-
had a good
Lord,
case.
Lord, I of course agree, Lordship, but the
But
point
then,
is,
today, no.
but the point is, Lordship, I was not intimated, though there is a direction to the respondent number 3 to intimate, Lordship. So that has to be, that is the fault on the part of the department. If they come up with the instruction that I was intimated, I will not have a case, Lordship. I will not pursue on that. Let them come up with the instruction
I'm not
one
on
day.
that point, Lordship is there. Here in this case, Lordship, regarding the maintainability of this petition, the principle of compassionate appointment is that the necessities, immediate necessities.
But how the immediate has gone, Lordship?
Cleared by the Supreme Court, Lordship.
2016, they will
There-
consider
is-
first time.
there-
2019, they will
there-
consider second time.
yes. But
They'll not intimate us for 4 years.
Now, so far, the case in your Lordship hand is that it is after 10 years, Lordship. That is the issue.
If Lordship, did they come up with the instruction, they have informed the petitioner.
No. Why the instruction is necessary? First of all, the question of maintainability, the principle of justice here in the compassionate appointment is only, it is not the right of the petitioner, Lordship. It is only the necessities, to pursue the immediate necessity, Lordship. That is not here in this case, Lordship. And therefore, I vehemently object regarding the maintainability of this petition.
I leave it to your Lordship, but Lordship, I still submit that the onus was on the part of respondent to inform me. Even if for me to the petitioner to come before this honorable court, she was to be informed for the rejection. She had no opportunity to know about the rejection only after the order.
That is too late now.
But the delay has been caused by the respondent
Okay,
not
heard,
informing me.
Mr.
D. Dekha, Lordship.
D. Degalan, counsel for the petition. Also heard Mr.
J.K. Goswami, Lordship.
J.K.
Additional
Goswami,
senior
and
government.
additional senior government advocate. For the respondents?
All the rest.
For all the respondents. Stop. The father of the petitioner, while serving as a Mohammedan in the Department of Municipal Administration, died in harness on 22/8/2014. Stop. Thereafter, petitioner met an application in the prescribed form
Yes, Lordship.
on 16/9/2014 for appointment on compassionate grounds. Stop. The case of the petitioner was, where's the DLC minutes?
It is not the Lordship, but the order of page 21 reflects he was recommended in 25th October 2006.
The case of the petitioner
25th October 2016, he
Was-
was recommended.
considered by the concerned district level committee in its meeting held on 25th October 2016 and was recommended for appointment on compassionate grounds. Stop. The state level committee thereafter in its meeting held on 19/7/2019 rejected the case of the petitioner.
Lordship, the SLC did not reject. SLC found to be eligible. Only the order thereafter was the order of rejection, Lordship. SLC found 7 candidates to be eligible. Order says we are not appointed for lack of vacancy, Lordship. The order is subsequent to the SLC meeting.
Okay, the state level committee in its meeting held on 19/7/2019 did not recommend the case of the petitioner.
No.
Due to lack of vacancy in the department. Stop. Thereafter, the Secretary to the Government of Assam, Urban Development Department, by an order dated 19th September 2019, issued an order dated 19th September 2019. to the effect that as there's no vacancy for consideration for appointment on compassionate grounds, as the posts have already been filled up in the Directorate of Municipal Administration, Assam, the recommendation of the district level committee could not be considered. Stop. Being aggrieved, petitioners before this court by way of the present petition. Stop. This court has noticed that the father of the petitioner died as early as on 22/8/2014, and he met his application. And the petitioner met his her application is her on 16/9/2014. Stop. Thereafter, DLC recommended the case of the petitioner on 25/10/2016. However, due to lack of vacancy, the petitioner case could not be recommended by the SLC in its meeting on 19/7/2019. Stop. The object of compassionate appointment is to tide over the difficulties of the deceased family immediately. Stop. However, it is more than 10 years that the present petition has been filed. And therefore, this court is of the considered opinion that the object of the object of compassionate appointment to the petitioner at a belated stage cannot be considered. Stop. In that view of the matter, comma, I find no reason. In that view of the matter, there's no merit in the present petition and is accordingly dismissed. You would have a better case if you had approached earlier.
Lordship, I didn't have the information. Lordship.
Yes.
Obliged.
Item 4.
May I please your lordship? In this particular case, lordship, the petitioner has approached against the impugned gradation list, lordship, dated 2/11/2023, which your lordship will find at page 34.
1 minute.
Page 34, lordship may kindly come. Page 34, relevant portion 35. In this gradation list, lordship, my junior, that is respondent number 6, has been placed above me. I am Nanda Das at serial number 2. Nanda Das at serial number 2. Lordship will kindly see para number, column number 6, 7. Initial date of joining in service. My initial date of joining service 7/5/1994. Purobi Nath above me at serial number 1. Above me, she is respondent number 6. Number 6.
In this matter, your lordship has directed us to take an instruction and we have received an instruction, but at this point, like regarding the promotion process, it is yet to be completed. So
let me
at
place
this stage,
the
your
let me
lordship
place
may
the case,
kindly
lordship.
issue the notice of motion.
There is some
And
urgency.
final
Let me place the
affidavit.
case, lordship. In this impugned gradation list, page 35, Purobi Nath at serial number 1. Her initial date of joining lordship will see 30/12/2004. 30/12/2004. 10 years after me. 10 years after me. And next lordship will see original place of posting. Her original office of the Deputy Director Fishery Silchar. Then mine is initially in the office of the DFDO Silchar, transferred to Dima Hasao, then again transferred back to Silchar on 1/21. Now, lordship, this gradation list has been prepared for further promotion from junior assistant to senior assistant. That is reflected in the heading itself, lordship. So, in the remarks column, the vacancy on which the eligibility and the date of effect of such promotion is also also been mentioned 31/1/2023. Now, Lordship, by page 34, this impugned gradation list was communicated to me to submit my objection within a period of 3 days, Lordship. I accordingly submitted my objection within 2 days. Objection, your Lordship will find at page 36. 36. I submitted objection. They were sitting idle on my objection, so I approached this honorable court. Honorable court's order at page 37. Court directed that no decision to be taken on the this is a provisional gradation list, and my objection is to be considered, and only upon finalization of the list they are to take a decision, and they should consider my objection, and till then status quo to be maintained. May I read the relevant portion, Lordship? Page 39, third paragraph. It starts from be that as it may. Be that as it may. Page 39. Relevant portion. Be that as it may, having regard to the nature of grievance expressed in the writ petition and the submission made at the bar, this court is of the opinion that the objection submitted by writ petitioner against the provisional gradation list would have to be disposed of by the authorities before finalizing the gradation list. It is only thereafter the question of promoting the candidates on the basis of gradation list would arise. And accordingly, they were directed to consider my objection and communicated me. Now, Lordship, I have communicated them. They have passed the speaking order at page 42. Page 42. This is a completely anomalous order, Lordship. There are several incongruity, Lordship, in the dates and everything, Lordship. And most importantly, the main ground taken by them is that, Lordship, they say at some point of time, I had given no objection for placing this lady, respondent number 5, above me. That is quite impossible because, Lordship, I have been regularly agitating. And may I read the speaking order, Lordship? Upon perusal of the order dated 18/12/2023, passed in...
Just read the operative part.
Actually, the entire order itself is relevant. From below, Lordship, I am reading, this committee is bound to follow. From there, I am reading, Lordship. The committee is bound to follow. In the middle portion.
You submitted your no objection.
No. I never submitted no objection. I have clarified that, Lordship. There is no point of submitting no objection for putting another person above me, Lordship. And that fact I have clarified by page 48 also. Page 48, there was some rumor in the office that I submitted no objection. I have clarified that fact at page 48. 8/6/2023. I have clarified that I have not submitted any no objection. If there any no objection, you give me the no objection. And that point will not arise now because the impugned gradation list was communicated to me to submit my objection. Accordingly, I submitted my objection. And admittedly, from the gradation list itself, it is evident that she is my junior. So I submitted my objection. Court directed them to consider my objection. And while going to consider my objection, they take a stand that at some point of time in the past long back, I have given no objection. May I read the Lordship, the speaking order that will clarify. From middle portion, the writ petitioner objector is bound to follow her earlier no objection dated 23/12/2021.
So that is there 23/12/2021.
No, no such letter is there, Lordship. No such letter is there. I have not given no objection. And Lordship, it is the settled position of law that one cannot barter away or waive his fundamental rights. I will obviously not give no objection to place a junior who is 10 years lower than me. I was never transferred on own request. It was once I was transferred from Kachar to NC Hills. That was on public interest. Then Lordship, I was transferred back to Kachar again on public interest.
Okay. What is your instruction?
Now, Lordship.
The promotion is yet to be completed, my lord. At this stage, my lord may issue notice the promotion matter, Lordship, and private respondent is also there, my lord.
Private respondent, last line, Lordship will see the name of Purabhi Nath is forwarded for approval.
But not
Page 42. Page 42. They are seeking to promote the private respondent, Lordship. Lordship will decide
any order pass is subject to the outcome of the petition, Lordship. May kindly observe.
Lordship,
issue notice, my lord.
in the earlier round of litigation also, the court directed that the provisional list may not be acted upon.
No, no.
Till they
till
take
the
a final,
discovery
till the
petition.
disposal, till the
We have
disposal.
passed
of-
that
Whatever it is, since there's some objection, don't fill up the post of signatory.
Yes,
Yes.
yes,
My lord.
yes.
Heard, Mr.
GJ Sharma, Lord.
G.J. Sharma and the counsel for the petition. Issue notice. MS
MD Bora,
MD Bora, Leonard,
Standing Council Fishery Department.
Standing Council Fishery Department appears for respondents, 1,
1 to 4 months, 1 to 5 months.
1 to 5.
6 is the private response.
Petitioner to take steps for service of notice on response number 6 by registered post AD within 1 week from today.
Yes.
List the matter after 4 weeks. Till the next retrievable date, comma. The respondent authorities are directed You want to stay off the gradation list only?
Because this gradation list is prepared for promotion to senior assistant.
Not to give effect to the impugned gradation list of junior assistant within bracket LD dated 2/11/2023.
In regards to the petitioner case, also.
Hmm?
Gradation is in petitioner and a private respondent case.
And
First, my kindly specify.
insofar as it concerns the petitioner and the respond number 6.
Deeply obliged.
Deeply obliged.
My lord, may keep my instruction the part of the record, my lord.
Hmm?
They have the instruction letter we have given.
The instruction submitted by the learned Standing Council Fishery Department is placed on
deeply obliged.
dated 3rd February 2020.
Deeply obliged.
Obliged.
Item 5.
Lord, the issue here relates to the conversion of people from the old pension scheme to the new pension scheme, which came in effect from the 1st of January 2004. The law is now settled by several court orders is that people who were appointed in vacancies prior to 2004, but then the actual appointment, even if it took place after 2001 and 2004, they will be considered or they will be given a chance to give an option for opting for the old pension scheme. Accordingly, my lord, the first list was drawn at Annexure 5. In Assam Rifles, around 4,000 people were found to be eligible.
Page.
Lordship would see Annexure 5, page 33. 16 January 2020. There is a list of, my lord, more than 4,000 people in which the petitioners also figured. Sorry, my lord, it's 3,951 persons were found to be eligible, 3,951.
Hmm.
Now, after exercise of options, my lord, they come up with a final list saying that these are the persons who are given the benefit of the old pension scheme. That is at page 168, Annexure 9. Page 168.
Hmm.
Annexure 9 is 21st November 2023. As per that list, my lord, only 1,331 persons, my lord, were conferred, my lord, this benefit. And the names of these petitioners, my lord, have been dropped without assigning any reason, my lord. That is the basic challenge, my lord. And other writ petitions have also been already filed, my lord, in this regard. Notices have been issued in other cases, my lord. So at this stage, I am praying only for notice, my lord.
You are appearing on behalf of all the respondents?
Yes, Lord.
Okay, heard Mr. P. Pathak, learned counsel for the petition. Stop. The petitioners here are aggrieved due to non-inclusion of their names in the list dated
21st November
21st
2023.
November 2023 for grant of all pension scheme, for grant of benefits under the all pension scheme. Stop. Issue notice. MS B. Sharma and the CGC appears on behalf of all. Notice and respondents are complete. However, extra copies will furnish so and so. Stop. List the matter after 4 weeks.
Apply.
Item 6, my lord, is in the same footing.
Item 6.
Same case, my lord.
7, all 7.
7, my lord, there is some difficulty because these persons, my lord, I was instructed in item number 7, my lord, they are mostly serving in Manipur. So the question of some jurisdictional difficulty would come. So they back to matter item 7, they would back to withdraw, my lord, to file it in the appropriate jurisdiction, my lord.
Mr. Item 7, Mr. B. Pathak, learned counsel for the petitioner. Press for withdrawal of this writ petition with liberty
To approach the appropriate jurisdiction.
with liberty to approach the appropriate jurisdictional court. Stop. Who appears?
I am for only respondent,
Mr.
UK Goswami. UK Goswami.
UK Goswami, learned CGC
Malo.
appears on behalf of all the respondents. Writ petition is accordingly dismissed on withdrawal with liberty as paid.
6, my lord, notice would go as in item 5.
The 6, same order.
Okay.
Item 6, B. Sharma is appearing. or
I'm
you-
appealing, Malo.
In item 6, you say you
5 and 6, same order. 7, my lord, clear with. Simply order.
Item 8.
The petitioner is at present serving as a junior administrative assistant, that is lower division assistant, in the establishment of the district and section judge Bodali Mali. He entered into service in 1998 as Mali in the establishment of district judge Kamrup, Guwahati, and was attached to the then district judge Mali. That on transfer of the district judge to different district, he was also transferred, and from Guwahati he was posted at in Malia's Industrial Tribunal Guwahati, and thereafter at Golaghat, then to Dhuburi, and then to Borgata Major. Annexure 2 Koli Major appointment letter. Annexure 1 is the appointment letter appointing him at Guwahati, and Annexure 2 Koli, then he was transferred, he was posted at Mali in the establishment presiding officer, page 23, my lord. And page 23. And thereafter he was posted at page 24, appointed at district as Golaghat as Mali, my lord. Then he was transferred to, then on transfer of the district to Dhuburi, he was posted at regular scales of pay as official, my lord. And on transfer of the district judge to Borpeta, he was at page 26, he was first appointed as Mali or contractual basis on the pay of 2021, and then he was posted as regular peon in the establishment of Borpeta on 15/12/2023. On 2027. The appointment letter is measure page 28, appointing him as a peon. Page 28, appointment letter page 28 measure. Scales of pay so and so in the establishment of district as Borpeta measure. And 2016 measure. That
page
is
28 is not readable at all.
28 measure. Page 28. Shri Vipul Kumar. Shri Vipul Kumar. Voice very fine to pull. Mali Shri Vipul Kumar, Mali or was employee
under the establishment of the judgeship is transferred and appointed purely temporarily on the basis of office peon in the office of the
You
district.
finish type copies.
My-
Finish type. This is not visible at all. How you are supposed to, how did the registry accept this?
That is, my lord, that is series of that, but the ultimate case, I am showing that how he is continuing, but ultimately he is at present, he is working in the district and session judge Bozali, and that is visible, my lord. It is, my lord, page 31, annexure 5, that the on the recommendations of the selection board with the establishment of Sri Vipul Kumar, who is working as process server, as Jagitari in the establishment of the undersigned is hereby promoted to the post of promoted on the basis of seniority term merit to the post of LD assistant created by government letter number so and so, dated so and so, in the ideal scale of pay so and so. So now he's serving there, my lord. And thereafter, my lord, what happened in 2007 when he was in Borbata, page 33, he applied for a provident fund account, my lord. Page 33, that is the letter written by the district judge, the accountant general, the application for admission to the general provident fund of Sri Vipul Kumar, office peon of this establishment. It enclosing here with an application for admission to the general provident fund, in duplicate of Sri Vipul Kumar, OP of this judgeship, and return the same to the show after putting GPF account number form here in my lord. So the GPF account was opened in the year 2007, my lord. These are the statement. And since 2007, in the December 2023, he has been depositing the provident fund amount at the rate of rupees 2,000 per month. And in return, government has been paying the tax to him, my lord. So thereafter, what happened, my lord? These are the statement, page 34, these are the provident fund statement, my lord. And during that statement, during the period, he took a loan of rupees 70,000 provident fund loan, and that's why repeat. And his date of birth was also incorrect. It was also corrected. Not all these things have been done, my lord. Now, my lord. Next slide. Annexure 8 is important, my lord. We are challenging it. Annexure is page 41, my lord. Page 41, this is the letter written by the accountant general to the district and sessions of Bodali for clarification regarding the subscriptions of the GPF and plus the contribution legal. Your letter number so and so. I am to invite reference to the subject cited above, and so that the as per para 4 of the existing provisions under defined benefit of pension, GPF would not be applicable of the Assam government employee joining of the government servant on or after 1/2/2005 as per government finance budget department number so and so, dated 27/9/2018, GPF account allocated to the AG Assam in contribution made where will be refunded with interest up to 2011, and no claim of interest of GPF accumulated money beyond 31/12/2018 is admissible to the subscriber. I therefore request you to direct the subscriber Vipul Kumar, holder of the GPF account number so and so, to submit final withdrawal application for the necessary authorizations of the end. That is, my lord, he has entered. That is a wrong interpretation. It is stated that those who entered into service after 1/2/2005, my lord. But petitioner has entered into service in 1998, my lord. So 1998 he entered into service, and 2007 GPF account was open. And from 2007 till today, he is paying the GPF amount, my lord. And here in this letter, the reference of the circular dated 27/9/2011 was mentioned as per this circular. If the circular was introduced in the year 2011, but even after for last 12 years, the petitioner has been paying the provident fund account, my lord. So after 12 years, that circular is imposed upon him, my lord. So it is the wrong interpretation of text. because he was entered to service in the 1998. That he has entered to service in 1998 has been recognized. Has been recognized by the Honorable High Court in the WBC, my lord. You'll also kind of see the Annex 11, page 44. When he was LDS Borbata, his file is WBC for non-receipt of the salary, my lord. In that WBC, it is observed by the Honorable High Court that he entered into service in the year 1998, my lord. So I read out one or two relevant para, my lord. The para 2, the writ petitioner on the basis of the appointment order dated 21/98, my lord. In 21/98, he was appointed. Issued by the District and Sessions Judge Kamrup Guwahati, was appointed as Mali as fixed salary of ₹900 per month. It is referred to that the appointment has been made as per the practice of procedure followed for a long time, whereby under the establishment of District and Sessions Judge engagement of the grade 4 employee in the event of requirement is permissible. By the nature of engagement of the writ petitioner, he was attached to Mr. K. Sharma, District and Sessions Judge, and moment of the judge by way of transfer and entitled moment of the writ petitioner as per the posting of the said District and Sessions Judge. In such manner, the petitioner served in different places of different district and copies of engagement. I have already pointed out the appointment letter, my lord. So eventually, para 3, next para, 46, eventually, when Mr. K. Sharma posted as District and Sessions Judge Borbata, the petitioner was appointed as a Mali on OS basis, the residential bungalow of the judge of the issuance of the appointment letter, appointment order dated 19/5/2005. While petitioner was engaged as a post of peon, office peon fell vacant under the establishment of the District and Sessions Judge Borbata, because promotion of the regular incumbent to a higher post. The petitioner being eligible applied appointment to the post of the office. Para 4, therefore, in the established practice and procedure followed over the number of the years, the board was constituted for making selection of the appointment to the post of peon, and the petitioner served. So in that way, my lord, he was appointed in the year 1998. Now, my
So
lord,
you are aggrieved by that letter only, isn't it? You are aggrieved by Annex 8.
Annex 8, yes. I want to stay of the Annex 8 and 9, my lord. By 9, District and Sessions Judge Bodali. So Bodali has issued a letter. Annex 6, Annex 7, Annex 9.
Mr. H.K. Das.
Annex 9, my lord. Page 42.
This is with regard to the service conditions of one employee in the District and Sessions Judge Bajali. So the High Court is necessary party.
Yes,
High Court will have to, it has to go before division bench. Is that
yes,
correct?
by virtue of the notification. Yes, my lord.
Yeah, my lord, the
Registrar General has not been made a party, my lord.
That is why.
No, is
RG has to be made a part of it.
Registration is not an issue because registration has no function, my lord.
This is an employee under the District and Sessions Judge.
Yes.
Bajali. Correct. It's a service matter.
Yes. District and Sessions Judge was made a
At
party.
least the Registrar General will have to be made a pro forma party, which is not done.
Yes.
And placed before division bench.
No, my lord, when the district judge is made a party, then the High Court judge, the High Court advocate automatically appeared in our case. Because here we have nothing to do along with the High Court, my lord. It is purely between Accountant General and the district judge, my lord.
Whatever it is, you are an employee of the District and Sessions Judge Bajali.
Yes.
Now the Article 235, all courts comes under the High Court.
High Court.
So
the High Court advocate will receive notice, my lord.
No.
there is a notification. Check out the notification.
There is a notification. Notification at the division bench. There is a notification. Two things, my lord, that notification, by virtue of that notification, this matter goes there and before the division,
Plus,
RG has to be made a party.
RG has to be made a party.
Then I will make an additional affidavit by making the High Court as a party. That matter may refer to
He has to
the.
file an IA lordship
But
for
my-
amendment of his petition and also lordship that annexer, which is not visible.
My lord,
Better you
that is
will-
the
better
fact
you
how
will
he is
withdraw
continuing.
the-
I want to show there how he is continuing. That is not so,
you
that is
withdraw
not so
this
important.
liberty to file afresh.
His ultimate appointment was, initial appointment was
You
98.
don't understand what I'm trying to tell you. This only the notification of the High Court.
That is why I'm telling my lord, if it is so, then by filing additional affidavit,
Not
I'll make
additional
the
affidavit.
High
You'll have
Court
to file
party.
an IA.
Then matter will refer to division bench, my lord.
You'll have to file an IA.
Yes, by filing IA. By filing IA, High Court will be made party.
Better in that way, better you withdraw this and file fresh.
Because
That is better.
I am not aware about this circular, my lord.
That is why I'm telling you.
Then I'll file an IA tomorrow because it will be referred to division bench. But my lord, his marriage is up to 13 only, because the district has given time up to only 13 February to withdraw it. If the stay order is not received, my lord, then this petition will be in fact suspended.
That, how can I help you? It's your fault.
IA can be filed tomorrow and get it listed before the honorable chief justice. Division bench is here.
Or you can withdraw this, file afresh, including your RG, go straight to division bench instead
to
of
division.
coming here, then
Yes.
this court referring you back to the division bench.
Yes.
Instead of that, you better file a fresh petition.
Fresh file. Then let maybe withdraw with the permission to file a fresh one, my lord.
File afresh.
That's better.
Mr. K. Sharma, learned counsel for petition afresh for withdrawal of the street petition with liberty to file afresh. Mr.
CKS Borua, sorry, for response number 1, CKS Borua.
CKS Barwal Leonards,
Government order আছে। He has some.
it appears for the response number 1. And
And
Mr. R.K. Talukdar, Leonard, standing counsel, AG, appears for response number 2. And petition, and Mr. P. Nayak, Leonard, standing counsel, finance, for response 3. Petition, on withdrawal, with liberty as paid for.
Item 9.
May I please, Lordship? Matter pertains to recovery of overdrawn amount, Lordship.
What's that order?
At page number 24. Amount, details of the recoveries, amount to be recovered 92,396.
What is your case?
This is that he was working as section assistant, Lordship. He retired on 31st of January 2021, Lordship. Thereafter, while his pension paper was processing, Lordship, the senior accounts officer sent this letter at page number 20, Lordship, Annexure 1, to the executive engineer, Lordship. In inviting a reference to your letter number so and so, dated so and so, on the subject cited above, I am to state that on scrutiny of pension papers and service book of the aforesaid incumbent, it is seen that pay on 1/7/2015, after allowing incremental benefit, should have been fixed at rupees 11,730 instead of 12,140. It is therefore requested to make necessary correction of pay with effect from 1/7/2015 to till the date of retirement, including fixation of pay under ROP 2017 in the service book with due attestation of the competent authority in a fresh page without overwriting in previous pages. The excess pay and allowances may be computed in the form of due and drawn statement after necessary correction. The total overdrawn amount also to be incorporated in Form 19 to effect recovery. After this letter, Lordship, page number 21, Lordship, the executive engineer resubmitted the pension paper, and in that, with that letter, they have annexed at page number 24, Lordship, details of the recovery, according to which an amount of rupees 92,396 rupees was sought to be recovered, Lordship. Subsequently, thereafter, Lordship, petitioner filed a representation
and at page number 25, Lordship. And with this representation, he has submitted an office memorandum, Lordship, at page number 26, Lordship. According to this office memorandum, Lordship, recovery of amount from retired government employee is impermissible, Lordship. At page number 26, Lordship. At point number 4, Lordship. The Honorable Supreme Court, while observing that it is not possible to postulate all situations of hardship which would govern employees on the issue of recovery, where payments have mistakenly been made by the employers in excess of their entitlement, has summarized the following few situations wherein recoveries by the employees would be impermissible in law. Point number 2, Lordship. Recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. And point number 3, Lordship. Recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. So he was getting from 1st of July 2015, Lordship. He is getting excess amount, Lordship. Under these two clauses, Lordship, now this amount cannot be recovered by the authorities, Lordship, and accordingly he filed that representation to waive the recovery process, Lordship. Thereafter, Lordship, one judgment is also I have annexed at page number 28, Lordship. From relevant page number 29, Lordship, from paragraph number 2. The petitioner who was working as assistant teachers in lower.
Yes, Nayab.
Lordship, two component has been sought to be recovered, Lordship. One is the excess payment, and due to whatever reason, Lordship, and other is leave salary, Lordship. Even if Lordship that wrongly calculated increment we may not like to recover, Lordship, but that leave encashment benefit, Lordship, we are capable of to recover, Lordship. These are the benefits paid to him subsequent to his pension, Lordship. So Lordship will issue notice at this stage.
Yeah.
There's a recovery process to be stayed, Lordship.
Recovery, no order has yet been passed, Lordship. It will go to the Accountant General. Accountant General issue the recovery order. Only thereafter he will cause of action will arise, Lordship. Right now it is
no cause of
only
action.
under contemplation.
No, already according to that senior accounts
This is
officer,
not an
Lordship,
order.
he has submitted the recovery documents.
Yes,
Lordship.
it's an interdepartmental communication.
So no recovery to be.
No. Any order has been issued from
No.
the Accountant General's office?
No.
No, Lordship.
Then
But they have submitted the recovery amount, Lordship.
no, submission is a different thing. But then the final order will be passed by the Accountant General, isn't it?
That order has not been passed yet, Lordship.
Then this writ petition,
No, Lordship, they are contemplating to recover the
so
amount.
this is on apprehension.
No, Lordship, already I have shown that all the details, Lordship.
No. Department has submitted to the Accountant General's office. All right. Accountant General office will pass an order saying that so and so amount be recovered from his monthly pension. Only then your cause of action will arise.
The pension,
This is only a interdepartmental communication.
this is, they are contemplating, Lordship.
I know they are contemplating.
This,
Let them issue the order.
that order has not been passed, Lordship. This is a letter from September 2021, Lordship. He has only been granted provisional pension, Lordship. Now they are going to overturn the amount from the pension which he is entitled for, Lordship.
The Accountant General office will issue an order. After that, your course of action will rise.
Lordship, let this matter come after a week. I have to get the instruction whether such order has passed.
Okay, on request made by Mr.
Land
Counsel for the petitioner, list the matter after 1 week.
Obliged, Lordship.
Item 10.
Yes.
My lord, the petitioner, Your Lordship, is a outsourced office field assistant, my lord, at Soigao ESD, my lord. ESD means, my lord, electric subdivision, my lord. Now, he already rendered more than 10 years service, continuous service. And in this aspect, my lord, the respondent number 3, the chief executive officer submitted a communication letter addressed to respondent number 2, that is page, my lord, 14. And the petitioner, page 14, my lord, submission of detail of outsourced manpower under GEC 2, my lord. Guwahati Electrical Circle, GEC 2. Now, my lord, petitioner name appear at page 15 under serial number, my lord, 82. Page 15, serial number left side, my lord, serial number 82, Usman Goni, outsourced cum field assistant, holding the post. And his period of service, 10 years. That is more than 10 years, 10 years. And he was initially engaged on 28/2011, on the right side, my lord. Now, what happened, my lord? And he also received his last salary, my lord. That is, my lord, page 21. Direct salary disbursement, my lord. This is through bank account, 21, my lord. On 18/5/2020. Assam Power Distribution Company Limited, at amount of rupees 16,566. But thereafter, my lord, my salary held up without issuing any notice. And therefore, my lordship, I made a representation dated 27, that is 20 July, that is page 23, my lord, addressed to respondent number 2. For releasing my salary from the month of May 2020. Because no any letter, no any show cause notice, no any termination is issued. Just verbally, respondent number 3 stated that I am not in service. That is that I have also narrated, my lord, under para 5, my lord, without issuing any notice. Whereas I have rendered continuous 10-year service, my lord. Paragraph 5, I have made this statement that the respondent number 4 on whims has interfered the service of the petitioner without any valid reason and told verbally that petitioner's service has not been continued without issuing any notice. And now, my lord, very surprising, the service more below, my lord, 10 years, their service, their salary already been enhanced. That is, my lord, page 24, annexure 5. I assail this office order because my name has not been enlisted in this enhancement list.
Yes,
Firstly, my lord, the petitioner is an outsourced worker. He's not a permanent employee of the APTCL. They were engaged through contractors. Now, his services admittedly were stopped in from May 2022. So he's saying that they were not drawing salaries as such. They were drawing commissions based upon their performance, and they admittedly they were getting ₹9 per bill that they were dispatched or the bill that they generated. From 2022 May onwards, he's not been rendering services, but there's no question of him being reinstated in service or him getting the area salaries being released to him. That question doesn't arise. As far as this office order is concerned, well, I'll come back with instructions whether his was considered or not, and why.
Which office order?
The one that he's referring to at page 24.
Because, my lord, below.
Where's your salary statement? That last one which you.
Salary statement, my lord, that is page, my lord, 16. 16, my lord. Yes.
51, isn't it?
16, my lord, for the month of January, my lord. Page.
No. Page 21.
That is the last salary, my lord. On 18/5/2020, this is last salary, 16,566. Now, question is, my lord, while I rendered more than 10 years continuous service, if I am terminated, the show cause notice is to be issued.
No,
Without
you're an outsourced person.
But question is.
Outsourced meter reader, isn't it?
Yes, lordship. but without any fault. He verbally saying that I am not in service.
Anyway, you let
I'll
us
come back
get
to
some,
it.
heard, Mr.
Give
Okay,
word.
we are non counsel for the petitioner, Mr.
B. Chaudhary, my lords.
P. Chowdhury, standing counsel, APDC.
For all the responses.
Shall receive instructions. How much time?
2 weeks, my lord.
Least after 2 weeks.
Keep your pleasure.
File your-
Item 55 from supplementary list.
May it please the Lord. In this case, the petitioner appeared in a competitive exam conducted by the Staff Selection Commission for selection of constable in the general duty for armed forces. Then, Lordship, in the year 2018, advertisement was published. The petitioner applied. At first, the computer-based examination was held. In that exam, the petitioner scored 48.92394 marks. Then, thereafter, physical examination was done. In that, also, the petitioner was successful. And then medical test was done, and ultimately result was declared. Where the petitioner scored 48.92%, he was not selected, but the person who scored 48.69, that is lower cutoff mark, that those persons were selected. Lordship, this is my case in brief. Lordship, you may kindly see the advertisement. The petitioner appeared under the ST category, Lordship. That page 28, the age limit is there. 18 to 23 years as on 1/8/2018. The candidate 4A, Lordship.
Yes.
Age limit 18 to 20 years as on 1/8/2018. Candidate should not have been born earlier than 2/8/95 and later than 1/8/2000. Then, Lordship, come to 4B. Code number 1, category SCS. 4B age relaxation codes available to different categories candidates for claiming age relaxation as on the date of returning are as follows. SCST 5 years. The petitioner's date of birth is at page, also you will find 56.
Page?
56. This is the application form. Serial number 4, date of birth. It is 5/6/1995. So he took the relaxation, Lordship, for ST because he born before 2/8/95. So therefore he took the relaxation of a ST candidate. Then thereafter, Lordship may kindly see page 61. NXRE. His mark in computer-based exam, it is 48.92394.
Where is that?
Score in Lordship may find score in computer-based exam part 1, part 2.
Yes.
It is 48.92394. Then Lordship may come to page 68.
Yes.
Postcode D and area code B. It is at the middle. For ST, marks 48.69775.
Yes.
Lordship, this mark is lesser than the marks I obtained. Therefore, Lordship, the selection of the process, selection process is not good, correct. Therefore, I may be selected for the post.
Yes.
Lordship, I have to take instruction, Lordship, because the cutoff marks of different categories of candidates are Lordship separate. Therefore, whether his cutoff mark is some other candidates more than the mark secured by petitioner, it has to be taken.
He is from extremist interested area, Lordship. And what is the cutoff mark? Yes, it
Okay,
can-
heard Mr.
Arsamal.
Jamal and counsel for the petitioner, MS.R. Devi, Leonard, CGC, shall receive instructions. When?
Next people.
List the matter after 1 week.
That may be fixed.
Date. 21st.
Obliged.
Lordship.
56.
May please, your lordship, this matter relates to removal of service, my lord. The petitioner, that is annexure J, page 33, my lord. He was working in the police department, my lord. This is the, peruse the findings of the departmental proceeding number so and so drawn up against constable so and so of this unit submitted R.I. Amir Khan, come inquiry officer. I agree with the comment of inquiry officer. He is removed from service with effect from 15/11/2020 for his prolonged unauthorized absence from government duties. His unauthorized absence from 19/1/2020 to 15/11/2020 is treated as no work, no pay. So, my lord, only he was removed only on the charge of, my lord, unauthorized absence, my lord. So, my lord, there was no criminal charge against him and also no financial embezzlement. Nothing is there. Only for unauthorized absence he has been removed from service, my lord. So, my lord, submission is that, my lord, his punishment is quite disproportionate, my lord, because my lord, the charges against him are minor, my lord. The offense is minor, so he may be inflicted minor punishments such as censure, stoppage of increment, reduction of salary. So this is my submission, my lord.
Why you're coming so late?
My lord, he has filed a departmental appeal, my lord, but nothing was done, my lord.
Where's the appeal?
Last, my lord. Minister K, my lord. It was not even received by accepted by the office because he was asked to submit, furnish medical documents, my lord. But all documents were not available with him. Some documents are there, my lord. I'll file additional affidavit, but my lord, so they were, my lord, asking the petitioner to submit medical documents in respect of his mother also, and my lord, in
So
respect of
this
him
appeal is
also.
still pending?
Yes, my lord. They have not accepted it, my lord,
Why?
because I have not, the petitioner did not, my lord, the medical report and the connected papers were there, my lord. All these papers were misplaced. So the petitioner, my lord, requested that he will produce the documents later on, my lord. Your lordship may kindly say enclose one medical report and other connected papers. But these papers were missing, my lord. So he requested them to give him some time so that he can collect again, my lord. But he was not given any time, my lord. So at this stage, your lordship
So
may
your
issue notice.
your departmental appeal has not been accepted. You should
Yes,
have approached this court immediately.
my lord, because of some financial problems, my lord, because he is not in service, my lord.
It's not in service in 2020 only.
Yes, my lord.
So you would have approached in
My
2020.
lord, he is the eldest son, and there are 7 and 8 members, family members. His father is also not there, my lord. Father also expired long time back, my lord. So that is why he has got family problems.
State, not wrong.
It is police department, state government.
Lordship, we have been provided with this, another brief, Lordship. I think the same name.
Gulab Hussain. Gulab Hussain. Okay, ma'am.
Removal from service, Lordship, and Lordship has to issue notice, otherwise we have to reply on this, Lordship.
What do you have to say on the delay?
Delay is there, Lordship, but it's on 2020, 3 years. 3 years, Lordship.
Delay I have explained in my petition
Where?
grounds. Yes.
Can it be taken up after some time, Lordship?
Okay.
Item 12 for admission.
This matter was heard by your lordship at length. I completed my part, then the part of my friend was yet, he used to do his part.
Lordship, otherwise also this is a part-heard matter. If Lordship takes this matter as a fixed matter, Lordship after 2 weeks, Lordship can dispose of.
This is a part-heard matter?
It was a part-heard matter. Your lordship was pleased to hear me entirely and was pleased to keep the matter as part-heard, my lord.
I'm only praying for a fixed date.
No, I've forgotten what
Issue was, I'll refresh, my lord. Issue was very simple, my lord. He was initially, there was a selection process initiated. Pursuant to that, he was appointed. My lord, there was all the procedural formalities in a recruitment process, advertisement, written test, interview, all was followed, and he was appointed. But what the respondents had done, my lord, they had appointed him in a fixed pay. Thereafter, that fixed pay thing continued, and finally he was regularized. And there is a scheme, compassionate family pension. It says that one has to go complete 1 year of continuous service. So my service was entirely continuous, my lord. There was no break in my service. And in that view of the matter, my submission was that since my service was continuous, this poor lady, she's a widow with 2 minor daughters, my lord. She's entitled for this benefit of compassion. You cannot wipe out the earlier service for your fault, my lord. That was my case before your lordship.
The power stand was that his regular service period less than 1 year. A fixed date, Lordship.
But HK does not counsel for the petition.
22 তারিখ মানে লইলো
On request made by Mr. P. Nayak, understanding counsel. BTC, isn't it?
Yes, Dr. BTC.
List down, when do you want? After 1 to 2 weeks?
22nd your lordship will take up.
Yes, on 22nd.
Lordship will keep it as part-heard.
As part-heard.
Item 16.
My Lordship, R.K. Talukdar. T. Borman on behalf of R.K. Talukdar.
Okay, also heard Mr. R.K. Talukdar.
T. Borman on behalf of R.K. Talukdar. Respondent number 8.
Counsel appearing on behalf of R.K. Talukdar for the respondent number 8.
Deeply.
16.
Please, your lordship. In this lordship, today I filed affidavit in reply, lordship.
You filed your affidavit in
That is
reply?
not in the record, lordship. It be
You're Mr.
B. Datta.
B. Datta.
On behalf of U. Datta.
Learned counsel appearing on behalf of Mr. U. Datta. Learned counsel for the petitioner submits that the petitioners have filed an affidavit in reply this morning, correct? You have filed it or you are filing
lordship.
it? You filed it or you are filing
Already
it?
filed, lord.
This morning. Registry to verify and place the same on record. List after 2 weeks.
17.
Matter relates to compulsion appointment. Here, what happened? Here, what happened? The petitioner, father died on 14/5/2012. Thereafter, he applied. His case was recommended by DLC. The same DLC had rejected the claim of the private respondent number 7, my lord. But ultimately, my lord, the state level committee, in its meeting held on 3/10/2019, my lord, rejected my case, being, my lord, for having spent the force of time
and my lord recommended the case of the respondent number 7, whose case was rejected by the same district level committee which had recommended my name. That is my case. Your lordship may kindly come to the SLC minutes first, my lord. Please. SLC minutes, your lordship will get at page 32.
1 minute.
Yes.
Is there a private respondent here?
Yes, respondent number 7.
Anybody
But,
appear?
yes, the notice has been served, but she has not appeared.
Yes.
Yes, you should kindly come to that SLC minutes, my lord, at page 32.
Yes.
Yes. And also we kindly come to the next page, page 33, my lord. And then also we come to the last, but the second last paragraph, my lord. The SLC examine. The SLC examine the cases of Srimati so and so and so and so, my lord. And also we kindly skip those. And also we come to serial number 5. Sri Udit Narayan Purikasta, my lord, the petitioner herein, my lord. Son of late Uday Shankar Purikasta Jugali, who expired on 14/5/2012. And so, my lord, then the findings, my lord, and the committee found that all the applicants have already spent their force for more than 2 years, and there were no vacancies during that period. Hence, the committee unanimously rejected their prayers in view of the above reasons. The last paragraph. The SLC examined the cases of Srimati so and so. Serial number 2 is the private respondent now. So, Srimati Seema Dev, wife of late Ashutosh Dev, who expired on 10/8/2013. Related to the date of my father, because my father expired on 14/5 and her husband expired on 10/8, and Sri so and so who expired so and so. Then lordship may connect on the next page, page 34. After careful examination of their cases, found that there were vacancies. Next page, page 34. There were vacancies available during that period, and also the applicants had not spent their force for more than 2 years. Hence, the committee recommended their case for appointment on compulsory ground in the post of grade 4. But whereas, my lord, if it also comes to the DLC minutes at page 24, the lordship will find that same DLC rejected the case of the private respondent number 7. Office of the Information and Public Relations, Barak Valley, so and so, my lord. Lordship may kindly see Seema Dev, educational qualification, class 9 passed. Date of submission of application is 9/9/2013. Whereas my date of application of submission of application is 21/7/2012. I had applied twice, my lord, and 21/3/2013. Grade 4, post applied for. Date of birth is 78. Mine, it is 94. Date of death is, my lord, my father expired on 19/6. Her husband expired on 14/5/2012. Then the sentence starting from, my lord, the committee discussed and examined all aspects and recommended serial number 2, Sri Udit Narayan Purkasta, son of so and so, which was pending in the last district level meeting dated so and so. The committee could not recommend serial number Simadev so and so due to want of vacancy. For want of vacancy, my lord, her candidature was rejected, but ultimately, my lord, the SLC, my lord, in his meeting, my lord, recommended her case, and subsequently, my lord, she has been appointed. And against her appointment order, I have come. So far as my case is concerned, on the date on which my case was considered by the DLC, my lord, there was a clear-cut vacancy, my lord. Still, my lord.
Where is the response 6?
No, this response 7 is
Oh.
the private respondent. Nobody has appeared for her. She has
No,
not come up.
notice is complete or not?
Yes, complete.
How do we know?
Well, I have checked up the records.
Which records?
The office notes. Office notes. I forgot the date today. I didn't check, my lord. On the last occasion I checked up.
No, this Lawazima Court Order 6/2023.
Yes.
This one, we can't accept this. Do you know her address? Respond number 7.
Yes. It was sent in an address, but it was
Can you
received
take
by
a
her.
dusty service?
Justice, we can do it.
Better you
Yes,
take it.
yes.
As per your consent, Lordship, we have filed our.
That we have.
No, government has not filed, my lord. Only director has filed. Government is yet to file this affidavit also.
Lordship,
Government.
response number 4 has filed.
And government, no, director.
Government will have to file.
Yes.
Lordship, we have filed our affidavit, Lordship.
You
Who
filed
is the
your affidavit.
director?
The director has filed it. Director is not the government.
Government of secretary. It's not the.
4 weeks time we will give it. 4 weeks time, so that we can take justice service.
So they. It.
Lordship, response number 4 has filed, Lordship.
That's what I'm saying. SLC is the government, isn't it?
Lordship,
SLC will have to file.
Lordship, we will file.
The chief secretary is the chairman.
Okay, Mr. M.R. Adhikari, learned counsel for the petition. Praise for taking steps for service of notice on the respond number 7 by dusty service to the registry of this court. Praise allowed. Petitioner to take steps for service of notice on respond number 7 by dusty service to the registry of this court within a period of 1 week. Thereafter, petitioner shall file an affidavit to that effect. List the matter for 2 weeks.
What date may be given?
List the matter again on today's what? 6th, 7th. Okay. 23rd.
Well, okay.
19.
Time for the respondent, Malot. Affidavit has already been filed, Malot.
None appears for the petition. Mr. UK Goswami. Learned CGC. Appears on behalf of the respondents. List after 2 weeks.
21.
Lordship, I am a bank official. I am in the present place of posting since 21, Your Lordship, April 21, Your Lordship. And in 22, within a period of 1 year, a transfer order was issued, Your Lordship. And I approached this Honorable Court, and the Honorable Court was pleased to stay the transfer order, Your Lordship, because there is a rule that the transfer policy says that officials are to be transferred every 3 years. And because only 1 year was there, passed only, therefore the transfer order was stayed, and he is still in his present place of posting in Fakiragram, Your Lordship. And it is almost about 3 years now. 2 months left, Your Lordship. Lordship may dispose it of, Your Lordship, because only 2 months left for the mandatory period of 3 years, Your Lordship, for transferring any person, Your Lordship.
The impugned order.
Impugned order is at 12, Your Lordship. This is the only format, Your Lordship. As such, this is not a formal order, Your Lordship. This is a format showing names of various persons transferred, Your Lordship. And my name appears at serial number 16, Your Lordship. Pratuspran Bhattacharya from Phokiragram to Silchar, Your Lordship. The transfer order was made, Your Lordship. That order was stayed by an order of the Honorable Court, Your Lordship, on 9/5/22. 9/5/2022. That was stayed, Your Lordship.
Where's the transfer policy?
Transfer policy is at 13, Your Lordship. Page number 13. At 14, Your Lordship, transfer officer. Page number 14, Your Lordship. Category B, Your Lordship, transfer officers. Item number 1, Your Lordship. All officers should be transferred every 3 years. That is the policy, Your Lordship. But in accident circumstances, of course, Your Lordship, if there is some exigency, they may be transferred, Your Lordship. But then the transfer order did not say anything about any urgency, Your Lordship. But anyway, Your Lordship may dispose it of, Your Lordship. And the protection for 2 months at least, Your Lordship. I may not be disturbed from my place of posting for 2 months. Hence,
In any case, you have completed 3 years, 2 months is nothing.
that is what, Your Lordship. That they might immediately, if this is disposed of here and the interim order is vacated, Your Lordship, they might immediately transfer. At least 2 months time maybe allow, Your Lordship, so that I may not be disturbed till 2 months.
When are you completing 3 years?
On 21/4/24, Your Lordship. On 2/4/24, Your Lordship. 2/4/24.
Yes, but
Lord, first of all, Your Lordship will see that transfer policy, whether it is having any statutory proof, is just a guideline. My Lord, the transfer here, it was a routine transfer. 258 officers were transferred by that particular, my Lord, they did not annex that. I have that copy. His number is, Your Lordship will find 205. My Lord, I'm just producing it, Your Lordship may look at. Now, if it is an routine transfer, my Lord, this policy guideline is not going to help him because it has got no statutory proof. I place certain decision of the apex court as well of this one of the court. So therefore, my Lord, only by virtue of an interim order, almost 2 years has gone by. They are taking advantage of that. And my Lord, from my experience, I can tell you, Lordship, whenever any bank employee or any employee comes up for staying the transfer order, the court in a routine manner is to pass that order, which is not a very healthy thing because, my Lord, there will be chaos, my Lord. What happened in a bank, Your Lordship will find nowadays, the appointment of the new recruitment is very less. And a person, if in one branch, 2 persons work, another branch suffered. So in this branch, it happens that way. The person who was transferred, he joined. And this person, his transfer order has been stayed. As a result, in a one branch, there are 2 officers. Now, my Lord, Your Lordship, can you see whether it is a mandatory or not, whether a bank officer is required to serve 3 years after that, after crossing 3 years bar, then he will be transferred. My Lord, in a landmark decision of IPS officer, her name is Rupa D. Madgi. My Lord, 18 years of service, she was transferred 40 times. Nonetheless, Supreme Court did not touch that. That, my lord, it was said that is the prerogative of the administration, and we are not expert to interfere with all this thing. Because she was in police service and due to certain reasons, my lord, it was required to be transferred. So therefore, your lordship will, in the regulation, your lordship will find, my lord, under regulation 74, it is said transferability. Every officer or employee is liable for transfer to any office or branch of the bank, notwithstanding anything contained in regulation. An officer appointed under so and so liable to be transferred. Now, in the regulation, there is no criteria that one will have to serve 1 year, 2 year, 3 year. This is due to exigency service at any time you may be transferred. Now, your lordship kindly see here, this person is going to, in a particular region, he cannot stay more than 3 years. And he is going to stay there for plus 6 years. And in this particular branch, almost 3 years. Now, the transfer orders, stay of the transfer order itself was not necessary to be done. My lord, I tried my best to, my lord, the last occasion, to convince the court, to persuade the court that this order is required to be vacated, but it was not done. And since it has come today, my lord, I will take your lordship to certain decision. What is the position of law in this regard?
That what I am proposing is we will close the writ petition.
Yes.
Since that he is going to complete 3 years,
My lord.
giving you liberty to.
My lord, your lordship can dispose of the matter, but then there should not be any order protecting that he may.
That's why I'm saying.
My lord, yes.
As the petitioner is going to.
It's up to the management, my lord, how they work out.
Yes.
That's okay.
Well, then,
2 months you should be ready to move out.
but then lordship,
Already been there for how many years? 3 years.
3 years, almost 3 years. Yeah.
Almost 3
And as my lord, your lordship is in the transfer policy. Is it not a statutory one at all?
But then that is the practice, your lordship.
Practice is a different thing
I'm not
altogether.
making any observations on that. I'll just say that since the petition is about to complete 3 years, there's no purpose in keeping this petition pending.
It's better to dispose of
But
that.
then your lordship may make an observation, your lordship. No vindictive action for instituting this case may be
My
taken.
lord,
by the-
that, how your lordship will pass that order? There is no
Because
vindictive.
Hurt
there is a
Mr.
tendency, your lordship, that
B.K. Bhattacharya,
R. Sharma.
hurt Dr. R. Sharma, then a counsel for the petitioner. Also hurt Mr. S. Datta, then a senior, standing counsel laws,
No, my lord.
senior counsel,
Representing the bank.
assisted by MS. Yes, Musari. For the respondent bank. For the respondent 1 and 2.
Yes.
Oblique, Assam Gramin Vikas Bank. Stop. By district petition. The petitioner is challenging the transfer order. Who is it? What date is this? Is it a transfer order?
That is how it was communicated, your lordship.
They didn't, my lord, annex the original order.
This is the original one which you have given me.
Yes, I have that. I think I have handed over to you, lordship. This one, right?
Yeah, this one.
Yes, no. Yes, my lord. Number is 25268.
205, yes. 205.
No, serial number.
205.
No, what transfer order? Is it a transfer order?
Yes, yes, transfer order.
Transfer.
Routine transfer, my lord, to various officers.
18/4/2022.
Yes, yes. His serial number is 268.
But here in the writ petition, it is 26/4/2022.
There is 31, your lordship.
Hmm?
And my serial number is a 16, your lordship.
No, this is something different.
Office posting transfer order
dated 18/4/2022. The officers are advised to release from respective branch on 34.
Okay, then this is not a transfer order. This is the transfer order.
Yes, yes, this is the transfer order.
Challenge the transfer order number 01/2022 dated 18/4/2022 issued by 18/14 by which the petitioner has been transferred from Fakiragram to Silcha. Stop. This court para on 9/5/2022 had stayed the order dated 18/4/2022 insofar as it relates the petitioner. Stop. On the strength of the interim order dated 9/5/2022, the petitioner has been serving as assistant manager, has been serving as assistant manager at the Fakiragram branch. And is continuing till date. Stop.
He's a branch head, Your Lordship.
It is
He was working as branch head.
branch head. Stop. It is the contention of the legal counsel for the petition that in terms of the transfer policy of Assam Gramin Vikas Bank, and the officers are to be transferred every 3 years. Stop. However, as the petitioner had completed only 1 year in the Fakiragram head branch,
Kokrajhar. Fakiragram branch at Kokrajhar.
Fakiragram branch at Kokrajhar, the same is not tenable in law. Stop. Para. After hearing the learned counsel for the parties and on consideration of the materials available under court, the petitioner is about to complete 3 years in the Fakiragram branch of Kokrajhar on the strength of the interim order dated 9/5/2022 passed by this court. Stop. As per the transfer order, as per the transfer policy of the Assam
Gramin Vikas Bank.
Gramin Vikas Bank, petitioner is due for transfer on completion of 2 years. Stop. As the petitioner is going to complete 3 years in the Fakiragram branch Kokrajhar on 2/4/2024, this court does not find any reason to keep this writ petition pending anymore. Stop. In terms, stop. Accordingly, this writ petition is closed. Stop. Interim order dated 9/5/2022. The interim order passed earlier shall stand vacated.
Lordship.
You can take back this.
Lordship, an observation may be made that the earlier transfer may be modified to some other branch maybe. Your Lordship.
No, I'm not interfering in all this. That is the bank's job.
Yes, that is not necessary at all.
Observation.
After
7.
It please, Your Lordship. In item number 25 to 27, they're analogous matter. 25 and 27, they filed the affidavit.
Oh.
But 26, they have not filed the affidavit, Your Lordship.
Who?
The government, Your Lordship.
Are you filing your affidavit?
Lordship, in 25 and 27, it is filed, Lordship.
How about 26?
And 26, we have received instruction, but these are insufficient, Lordship. And
So you want some time?
yes, Lordship, or it can be heard on the basis of 25 and 27.
But different counsel is appearing, your lordship.
Oh.
They may like to file their reply. Therefore, I'm saying. Wait.
If they have the similar instructions, Your Lordship, copy may be served to us, Your Lordship, on that basis, since they are separate matters, Your Lordship.
Okay, Lordship, they can have it.
Are you filing or not?
Lordship, the instruction is insufficient. They have.
No, that's why I'm asking you, are you
Yes,
filing?
Lordship will be filing.
You want to file?
Lordship. But
You
these
want to-
two we have already filed. They
That
have
we-
not filed
that-
any
That we
reply.
have noticed. That
Lordship.
we have taken note of.
Yes, Lordship.
Only item 26. Are you
Only
filing? If
26.
you are not filing, you give the copy to,
Lordship will be filing.
you will file.
Your Lordship.
Heard, Mr.
R. Sinha for 25 and 27.
R. Sinha, learned counsel for the petitioner in WBC 3047 of 2020. As well as Mr.
HR does.
HR Das, learned counsel for the petitioner in WC 2958 of 2022.
I'm also appearing for 3045.
MS M. Bhattacharya, Leonard, additional senior government advocate. Praise for how much time?
2 weeks, Lordship.
2 weeks time to file affidavit, counter affidavit in WBC 2958.
2958, yes, Lordship.
Praise a lot. List after 2 weeks.
Your lordship, there is an interim order that may continue till then.
Interim order
And
passed.
others, Lordship, it is filed, but they have not filed any rejoinder, Lordship.
We'll file it. Let it come up.
Lordship, in item number 26 as well, there is an interim
Interim
order
order passed.
with respect to serial number 1. That may continue.
In both the petitions, in otherwise in item number 25 and
Interim
26.
order passed really to continue
Yes.
till the
Deeply
next.
obliged.
Obliged.
Oblige, yes.
28.
Lordship, we will file affidavit in reply. Some time may be granted.
Your good name, please.
MST Begum.
MS T. Begum, learned counsel for petitioner. Praise for how much time?
Lordship, 1 week.
1 week time. To file reply to the counter filed by the
Respondent
respondent.
number 3.
Respondent number
3.
3.
3 and 4, Lordship.
This is.
Four.
Yeah. Comparison number 3.
By the respondents. So, praise the Lord. List after 1 week.
Yes, oblige.
29.
Yeah, please, your lordship. Lordship, item number 29 and 31, lordship, that may be taken up some other days, lordship. I have some personal difficulties in this.
You're Mr.
D. Sharma, lordship.
Okay, on request made by Mr. D. Sharma, learned counsel for the petitioner. List after 2 weeks.
2 weeks, lord.
Same order item 31.
Highly obliged.
32.
Item 32.
None appears for the petitioner. You appear?
Yes, Lord.
MSM Bhattacharya, the additional senior government advocate appears for the respondent number.
1 and 4, Lordship.
List after 2 weeks.
33.
Lordship, this I has been filed by the Union of India, Lordship, seeking modification of the interim order because the disciplinary proceeding has been stayed. Not fully, Lordship, this court has stated that we can proceed with the inquiry, but no final order. Now the inquiry has been completed.
1 minute.
Matter relates to the Lordship, his cancellation after, of his caste certificate, so he has to, job has to go, Lordship. He obtained a job as claiming to be a ST candidate, and that ST caste certificate has been cancelled. Now, Lordship, he has also filed a writ petition. Let the both of them come together, challenging that order.
1 minute.
Lordship will file our affidavit in opposition in the WPC.
Not WPC, in the IA.
IA Lordship and reply in the WPC Lordship.
Where's the IA? In the IA, you write, had Mr. B. Chakravarti and SCGC for the applicants. Stop. Issue notice. Mr.
R. Dekalot.
R. Dekal and the council appears for the sole opposite party and prays for how much time?
2 weeks Lordship.
2 weeks time to file objections.
Lordship and interim may continue.
Prayers allowed. Next after 2 weeks.
Lordship, in that case, Lordship may fix a date, Lordship. Any date after 2 weeks, Lordship.
26th. In the main petition, it's a hard Mr.
R. Dekalot.
R. Dekal and the counsel for the petitioner. Stop. No. Cancel it. Mr. R. Dekal and the counsel for the petitioner prays for how much time? 2 weeks time to file reply to the counter filed by the respondents. Praise allowed. List on 26th.
34.
May I please, Your Lordship, kindly pass over for timing, Lordship.
Why?
Arguing counsel on leg, Lordship. Mr. JMS Chaudhary on leg, Lordship. Kindly pass over for timing.
35.
May please, Your Lordship.
As this case is prior to 2015, and the SLC Lordship, when it was been placed in the 2022, has rejected that on the ground that he has not completed 18 years of this thing, Lordship, of his years. And DLC already had once recommended. So what I propose is that, Lordship, because his application was 2008 perhaps. So by now he has completed, I think, 18 years of age. So once again, I will request the DC to place the case before the SLC. And if SLC thinks with him, the SLC may consider. That is fine. That's why I'm proposing that, because the DLC has already.
So you want some time?
I want some time to write a letter to the DLC, because as DLC already have recommended. So kindly place the same before the SLC.
Mr. A. Shaban and counsel for the petitioner. Or the request made by Mr. UG.
CKS Borough.
CKS Borough. That's the government advocate. When do you want?
3 weeks time, Lordship.
Please be better after 2 weeks.
Yes, sir.
36.
May it please your lordship. Your lordship may kindly see the last order dated 9/1/2024.
Yes.
No affidavit has been filed till date, my lord. Although the order was very specific that it had to be filed on or before 2nd of February. And the observation was that in case the affidavit is not forthcoming, then the court may consider directing personal appearance of the concerned official. It was at the instance of my learned friends.
I had submitted before, my lord. This is, my lord. Nothing is forthcoming, my lord. Perhaps we have to concede. Because, my lord, the person, the petitioner, though wrongfully.
Forest Department?
Yes, my lord.
Forest
Wrongfully, the VRS was given, but which was taken back after a long period of time. And DP was initiated in 2010 and it was continued again in 2023.
So we'll call for personal appearance.
No, my lord, it can be considered, my lord.
If he is considering, my lord, then your lordship can dispose of the matter by setting aside the impugned order. What has happened, my lord? The petitioner retired, proceeded on voluntary retirement way back in the year 2012.
No, are you considering on instructions?
I'm conceding, my lord. I have
On instructions?
instructions, my lord. Nothing is there, my lord. Nothing is forthcoming. Or perhaps if lordship wants, I can have an instruction 2 or 3 days after 2 to 3 days. But otherwise, I have. Otherwise, I was ready to consider next date or 2 or 3 days also because nothing will come because nobody can justify this kind of delay.
Where is the impugned order?
Impugned order is Annexure 20. Annexure 20, your lordship
69.
will find at page 69. Well, may I just give a preface, my lord? The petitioner retired on voluntary retirement, proceeded on voluntary retirement in the year 2012. And after her voluntary retirement request was accepted, she pressed for grant of pension and other benefits. Now, it was not done all along, and suddenly this order came in the year 2023, seeking to revive a DP which was pending at the time before she was allowed to go on voluntary retirement. So this cannot be justified in any circumstance. After 10 years and more so, after the person has been allowed to proceed on voluntary retirement, how can the DP be revived now? More than 12 years have passed by. So that is the situation. My learned friend also wanted to make his submission on the last date. He fairly submitted that he had to concede to the prayer. But till to have the instruction from the department, the last opportunity was granted.
See, the issue is, if there's any conceding, it can be considered only by the Advocate General.
In that case, my lord,
he'll have to have a written instruction.
I will bring that into instruction, my lord, because if this time I get
list it on Friday, you get a written.
my lord, can it be on Tuesday, my lord? Because
No,
I have to
Tuesday.
Wednesday.
Wednesday is holiday.
I have to communicate this order. I have communicated twice. Nobody is willing to take this burden.
Otherwise, my lord, your lordship can decide it on the face of it because the issue is simple. I retired on voluntary.
That's why I want to give him one last chance.
My lords.
After that, we'll finish it.
My lord.
So in that case, if your lordship can have it on 15th or 16th.
15th, 16th, there's some difficulty for this court. So we can have it on 19th.
19th.
Third, Mr. S. Datal and a senior counsel for the petition. So, Mr. D. Gogoi and the counsel, the standing counsel, Forest Department. Press for a last chance to enable him to receive written instructions. Stop. Press a lot, list on 19th.
Well,
it is made clear.
I'll make sure.
Case shall be disposed of on the next returnable.
19 something, I think.
Well, there is an interim order that may be continued.
Interim order passed earlier to continue.
Okay.
Time being item 56.
My lord, where is page 12, my lord? I have made submission regarding the delay, my lord. Page 12, my lord, at the top. So far as the delay in filing the instant return is concerned, there is violation of fundamental rights, my lord. So the delay may not be fatal. There are a number of Honorable Supreme Court decision in this regard, my lord.
Yes.
Lordship, I have gone through, but Here, the petitioner has been repeatedly given opportunity, Lordship, to come back and rejoin his
No,
duty,
no,
Lordship, but he has failed.
what the petitioner is challenging is the quantum of punishment imposed.
Yes, Lordship, but
So that is a different thing. Now that the
And
departmental proceeding is complete.
departmental proceedings also initiated, but this appeal, what they are setting it to an appeal, this doesn't seem to be so, Lordship, because these are not in proper format and properly addressed, Lordship. This is there, and they are telling this is not taken into consideration. This is also nothing to prove all this. And the medical issues that they are, that means what they are contending, Lordship, this is also not been sufficed here in this writ petition.
So at this stage, your lordship may issue notice, my lord.
Why should I issue
If
notice?
if they file affidavit, we will file a reply, my lord. We may be given opportunity because we did not get any opportunity.
2020 punishment. In 2024, you're challenging it.
My lord,
How can I issue notice? You have to satisfy this court. with
yes, my
regard
lord,
to the
because there is
delay.
violation of fundamental rights. There is right to violation of right to life and livelihood, my lord.
Those 3 lines.
Regarding my lord, this I have got, my lord.
See, you said
there are
you filed an
number-
you said you filed
Yes,
an
my lord.
appeal.
Yes, my lord.
And the appeal has not been accepted.
Yes, my
How
lord,
do you
that
know
is
that?
there.
How do you know that?
So, my lord, your lordship may give a direction to submit an appeal once again along with medical documents.
Now
Because
it's too late.
it was not accepted only on the ground that
If
he
you,
did not.
if you have approached this court
Yes, my lord.
immediately after your appeal was rejected, this court could have given that direction.
Because,
But
my
today,
lord,
2020,
there are, my lord,
2024,
he
given
had
that
to
direction.
maintain his family, my lord, because there the question of financial, my lord, soundness is required, my lord, to approach the Honorable Guwahati High Court, my lord.
You take instructions and come back.
Okay, Lordship.
Heard SP Chaudhary and the counsel for the petitioner on MSM Bhattacharya and the additions in the
But instruction regarding status of appeal or
status
Lordship?
with regard to the appeal filed by the petitioner. With regard to the status of the appeal filed by the petitioner, we didn't make it annexure K to the writ petition. When do you want?
Next week, Lordship?
21st.
Item 37.
Oblige your Lordship.
Ediva, your lordship, I'm putting the list of dates, Miller, for convenience of listener. Here, Miller. Issue involved in this case, Miller. Petitioner got selected and offered or received offer of appointment for the post of junior technician diesel in ONGC, Miller. And thereafter, on the quota of disability category, mark for benchmark for hearing impairment, having
Health department for my new year's active. He for my health council. He is on late in court number 20.
In fact,
he has filed the affidavit also, my lord.
He also filed.
yes, I know.
Let him come.
Affidavit. I have received.
For the
affidavit.
time being, my lord, let him come. my lord.
Time being.
Okay. After some time.
38.
My lord, in this case, we need to file affidavit in opposition, my lord, on behalf of the Food Corporation of India, my lord. 3 weeks time may be granted, my lord.
Lordships, it is relating to compassion appointment. It should be immediately to give assistance. Already they have delayed. And earlier, because my friend, short date may be given, Lordships, 1 week. 3 weeks.
Now, 1 week will not be able. At
Earlier
least, my lord, 2 weeks, my lord.
Last Lordships, it was.
It is
31/7/2000.
Last time also you were given 4 weeks.
2 weeks, my lord, at least.
Okay.
Date may be fixed.
Third, Mr. F.U. Barbuel and the counsel for the petitioner. On request made by Mr.
B.K. Singh.
B.K. Singh, learned standing counsel FCR. 2 weeks
My lord.
time is allowed to file counter affidavit. List on 26th.
26. Oblige.
39.
May I please, Your Lordship? My Lordship, I am accredited engineer, my Lordship. Earlier in the year, I was terminated, my Lordship. Thereafter, I approached before the Honorable High Court. Honorable High Court directed the respondent authority to conduct disciplinary proceeding, my Lordship. I faced the disciplinary proceeding, and after facing the disciplinary proceeding, I was reinstated, my Lordship. No charges was found against me, my Lordship. In the meantime, some of the person filed one PIL, my Lordship, and the Honorable High Court ordered the respondent authority to dispose of the representation of the petitioners of that PIL. Thereafter, in the proceeding, my Lordship, accountant of my office was charged, my Lordship. I was asked to submit as a witness, come as a witness, my Lordship, and I came as a witness. Thereafter, no charge sheet, nothing, my Lordship. A so-called notice was issued, and I am terminated again, my Lordship. So my humble submission is that I have already faced disciplinary proceeding, my Lordship. My order may be seen 20.
You file your affidavit?
My lord, I have not, but my lord, the facts are very clear. He has annexed everything here. My lord, there's a PIL 80 of 2021. I have a copy of the order.
No, but are you not supposed to counter the allegations made against you?
But the facts, just there's one fact, my lord, that I would like to point out. Page 3, my lord, he is a party in this PIL. At page 3, Surojit Roy, the current petitioner. So, my lord, there were certain anomalies, and in pursuance of this anomalies, the court had directed the DC to look into the representation of the petitioner, and in pursuance thereof, my lord, an inquiry was conducted by the office of the DC. So, after the inquiry was conducted, he was given handed over a copy of the PIL, and he was asked to reply to all the allegations that have been made in the PIL. And accordingly, at page 28, he has filed his PIL. It is there. His reply is there at page 28. In pursuance of the PIL, my lord, the DC, he published an inquiry report. And that particular inquiry report was handed over to the office of the Commissioner PNRD. Once PNRD received that particular inquiry report, they issued a show cause notice to the petitioner along with that inquiry report, which is at page 30, my lord, the show cause notice. He replied to the show cause notice, and after his reply, which is at page 31 and 32, we have passed the termination order, my lord. He is a contractual employee. He cannot, my lord, say that the principles of natural justice have been violated, because at the stage of inquiry, we heard him out completely. He filed his reply to the PIL. Thereafter, we handed him the show cause notice. He again filed his reply, and thereafter we terminated him. And my lord, you would see in the first round of litigation, the charges that were leveled against him is that the Pradhan Mantri Awas Yojana, the houses that were constructed under that scheme, he was a part of it and they were incomplete. And the second round of litigation, due to which he is here before this honorable court, my lord, the charges are completely different. This time the charges are pertaining to misappropriation of funds. So as a contractual employee, anyways, my lord, the service rules will not apply to him, considering the fact he's not a government servant holding a civil post. So this is completely a valid termination order. My lord, look at every stage. He has been handed over. He has been given an opportunity to place his case before the commissioner.
So that's why at least you can bring that on affidavit and then we can dispose it off.
We'll dispose it off, my lord.
My lord.
You can file an affidavit to that affair.
If my lord directs us to that.
Yes.
My lord.
1 week I can give you.
1 week. 10 days time maybe given, my lord.
Okay.
I'll mark it.
What SP Laska, learner counsel for the petition. Mr.
P. Handing
on
behalf of K.
Counsel appearing on behalf of Mr.
K. Korn.
K. Konwa, learner standing counsel.
Additionally.
Additional Advocate General. is allowed 2 weeks time to file a affidavit, counter affidavit. I'll give a date.
My lord, a date may be given, my lord.
List on 29th.
Highly obliged, me.
Item 40.
Lordship, respondent number 1 and 2 and 3 has filed the affidavit, my lord. I need some time for filing reply. 3 weeks time, man.
Okay, Mr. SK Das, let me count for the petitioner. Praise for filing reply affidavit. Praise for 3 weeks time to file
Yes.
reply affidavit. To be counter filed by the respondents.
2 and 3, my lord.
2 and 3. Stop. Rights allowed 3. List after 3 weeks.
After this, any date may be fixed.
Okay, 1st March.
Fine.
List on 1st.
Fine.
But council is not here. Registry is also directed to place the counter affidavit filed by respondents. Respondent
2 and 3, my lord.
2 and 3 on record.
My lord. Over. Deeply.
42.
My plea, Your Lordship. Lordship, I have to submit the affidavit in opposition, Your Lordship. I pray for some time, Your Lordship. It is the first date.
You are appearing for?
Respondent number 7.
How about the other respondents?
I'm praying for it, but on item 6. They were directed to actually complete the numbers of the information in their part.
Yes. You have also not received.
We already have the copy, my lord.
No matter. The copy that the one actually that time of filing of the requisition. There are the date, the requisition. 23 and the certificate that has been produced is of 10/11/2000. Actually, states that actually those expeditions are actually included before filing the date.
Then we will sharply again, my lord. Extra copy.
Okay.
Person to the other note.
Mr.
HL, my lord.
Learned counsel for the petitioner shall furnish requisite extra copies to the learned counsel appearing for the official respondents. Stop. Mr.
AAR Karim, Your Lord.
AAR Kalim, learned counsel, enters appearance on behalf of respondent number 7.
7.
And prays for how much time?
2 weeks.
2 weeks time to file counter affidavit. Praise allowed. List after 3 weeks.
My lord, date may be fixed. Not listed, my lord.
1st March.
Hello,
And
please.
3 weeks time.
Already 3 weeks.
Oblige, Your Lord.
Item 57 from supplementary list.
In this case, they are receiving the transfer order, Lordship. Obtaining stay, Lordship, the matter not listed, Lordship. We have filed our affidavit, Lordship, that since 2016, he is in this place, Lordship.
Okay, none appears for the petition. Mr. SS Roy Leonard CGC appears for the respondents. List. The
On
matter
13th, Lordship.
again on
13th, Lordship.
not next week.
Lordship, we have some urgency, Lordship.
20.
Let it be on 22, Lordship.
22nd.
Item 44 and 45 for orders.
Wait, this is not. The review petition has been preferred against the order at page, my lord. 84.
Page
84, my lord. Relevant portion page 85, my lord. Starts from 85. Paragraph 3, my lord. It must be brought on record that neither the petitioner nor the respondent number 5 is eligible to hold the post of headmaster in charge in terms of Rule 14.2 of Assam Secondary Education Provincial School Rules 2018, inasmuch as both of them has not completed 10 years of teaching experience. The respondent number 5 further does not have the B.Ed degree, whereas petitioner has B.Ed degree. It is admitted fact that the respondent number 5 is senior to the petitioner. However, considering the fact the petitioner and the respondent number 5 has not completed 10 years of teaching experience, and also that the respondent number 5 does not have B.Ed degree, the appointment of respondent number 5 as headmaster in charge of Tilapura High School, District Dhubri, cannot stand the scrutiny of law of 2018. Accordingly, the matter remanded back. She had held that I did not complete the 10 years of service, whereas I was appointed on 16/3/2001. I was appointed in the year 2001, and I have completed more than 20 years of service.
But do you have B.Ed degree?
I have the B.Ed degree, my lord. And my lord, initially, my lord, I was appointed in an MB school. Subsequently, my lord, that school was amalgamated with a high school, with the present high school, my lord. And presently, I am working in the same high school. My lord, in the case of Minaram Kumar, my lord, this honorable court held that the period work in the ME school should be counted towards the seniority. If that is so, my lord, then I will complete my 10 years of teaching experience, my lord. Lord, should we kindly peruse? और एक That's point.
This review is filed by whom?
Filed by the Monwar Hussain, who have the B.Ed degree, my lord. Petitioner.
Petitioner
The petitioner of the earlier.
You were represented by a council.
Yes, my lord.
The council himself said that you have not completed 10 years. What else can we do?
My lord, that is true, my lord. That is true.
Then
That is true.
how
That
can we
was
ever-
in mistake in my lord, on the part of the council, my lord, in fact. But the fact remains that I have completed more than 20 years of service.
Yes, what is this?
My lord, Minaram Kumar Lordship, if Lordship peruses paragraph 21. In my judgment, the instant case is also one where graduate teacher of ME school cannot be segregated from the graduate teachers of high schools once their services have been amalgamated. More so, when they have the same pay scale, have the same qualification, and were recruited by the same process of selection. Neither is there any condition in the amalgamation order that the past service of graduate teacher of ME schools after amalgamation would be wiped out. In the view of that, I have taken, there is no merit in the contention that the learned counsel for a petitioner that private respondent cannot be treated as graduate teacher within the term graduate teacher referred to in Rule 2N of Rules of 2003. So, my lord, here, this honorable court held that the period, my lord, served in the ME school cannot be segregated from the teaching experience. And in my case, my lord, I have not completed 10 years of service in the high school, but I have completed more than 20 years of service as teacher. I am a master degree holder, my lord, along with the B.Ed degree. And ROP says I have abstracted the my lord, division of pay rules, my lord. Pay scale is the same. The high school as well as the ME school. The graduate incumbents, my lord, they are enjoying the same pay scale. They are enjoying the same pay scale, my lord. So, my lord, my service under the ME school cannot be, my lord, wiped out while counting my teaching experience. This is my limited case before your lordship. If the past service in the MA school is counted, I have completed more than 20 years of service as teacher, my lord. And I have got the teaching experience of 10 years, which is required under the law for being appointed as the headmaster in high school. That is why, my lord, I have prepared this review for your lordship for counting my past service. And in the notification, I have notification dated 1 March 2003.
1 minute.
1st of March 2003, my lord. I have given a, my lord, one-page copy, my lord. Just now I have handed over. Yes, my lord. In this notification, my lord, the governor of Assam is pleased to notify that in respect of the assistant teachers with graduate degree who have worked in intermediate scale in provincialized high schools, higher secondary schools, seniority of service will be counted from the date of their joining as assistant teachers.
So you are an assistant teacher?
Yes, ma'am. So, my lord, in view of this, my lord, there is an inadvertent mistake in the judgment impugned, my lord, which was due to the fault on the part of the counsel of the petitioner, my lord. In fact, my lord, it was not presented before lordship properly at the time of taking up the matter for final disposal.
Are you still holding in charge?
No, Lordship. After Lordship, what happened, Lordship? After your Lordship's order, Lordship, the matter, your Lordship remand back the matter to the authority. And in compliance with Lordship's order, Lordship, the impugned order has been issued, that is 11/4/2023, whereby I was allowed to hold the charge.
Now that order is also now put to challenge. The writ petition is also pending. Now this order will stay. Now, Lordship, so my responsibility.
No, what order was passed?
Your Lordship has passed the order on 28/7/2022, against which the review petition is filed. Now, by this order, Lordship has remanded back the matter to the authority for a fresh consideration. Now, in compliance of Lordship's order, page 92, Annexure 24, the order dated 11th of April 2023, it has been issued, whereby the private respondent is allowed to hold the charge. Now, this order is now put to challenge by this review petitioner, Lordship, where Lordship, this order has been stayed. So, Lordship, in my respectable submission, in review, Lordship, nothing is survived.
This order is state.
State, Lordship.
My review is for
Against that,
limited
Lordship, I
purpose.
filed this IA. That IA is now pending in the writ petition.
My-
Vacating entire. Now, so far, the
Where's the order staying this order?
Lordship may take up, maybe please should take
Page
up the
94, my
IA.
lord.
IA
Page
filed
94
by the,
of the review petition, my lord, page 94.
it's 95. It starts from page 94. Page 95. The last line, Lordship, page 95, it has been observed.
1 minute.
Sorry.
Yes. Then
But the submission is that he has completed 10 years of service. But the rule says that 10 years of service as a graduate teacher, that is the difference. He may complete more than 10 years of service as an assistant teacher. But here the rule says to become the headmaster or to hold the post of headmaster even on in charge basis, the requirement of rule is 10 years of service as a graduate teacher. Now, earlier he was appointed in a ME school and he is drawing intermediate scale and his cadre is also junior. Then the respond number 5 and he received the graduate scale of pay only with effect from April 2018. And it is in his service book, it is recorded. Now, his submission is that since I was appointed in 2001 in a ME school, my service period should be counted as a teaching experience. But the rule says it is not the teaching experience. It's 10 years of service as a graduate teacher. Now, who is graduate teacher? The teacher who is receiving graduate scale of pay. Now, so far the response number 4 is concerned, he receiving graduate scale of pay with effect from 1/1/2013. But admittedly, both the petitioner as well as the respondent 4, they are not eligible to hold the post of headmaster. Since the respondent number 4 is not having the requisite qualification of BEd, and so far the petitioner is concerned or the review petitioner, he is also not completed 10 years of service. So in that context, the matter was remanded. Now, considering the Lordship, the above aspect, Lordship, the director has issued the improved order. Since I was senior teacher, until the next arrangement is made, I was allowed to hold the charge. But after staying this order, the inspector of school is now holding the charge. And so far, the BEd is concerned, Lordship, his BEd is obtained through off-campus on distance mode, Lordship. As per Rule 11.2, that is also not permissible.
where's the rule? What rule is it?
The 2018 rules, Lordship. I am holding the rule. But the rule under Rule 10.1 Schedule 3.
So page.
Yeah. It's equal to good. Yes. What's page 54? Decision is made under rule 10(1)(2). Two lordship, graduate teacher. Graduate, postgraduate from recognized university with at least 50% mark in either graduation and post-graduation or its equivalent. The Bachelor of Education BEd from National Council of Teachers Education recognized, but this is important. But degrees obtained from off-campus and distance education institutions shall not be considered as valid. Now here in the instant case, the review petitioner as well as the lead petitioner, he obtained the BEd degree from Jamia Millia University through distance mode. So in view of this rule, the BEd degree is not valid. That is second aspect. And the first aspect is that till date lordship, the review petitioner has not completed 10 years of teaching experience as a graduate teacher.
1 minute. What's that rule 14?
Rule 14(2). So I am holding the rule number B. Rule 14(2). 14(2). These are the lordship eligibility criteria. Page 36, lordship. May I read, lordship? Eligibility for the post of headmaster. Page 36.
36.
Page 36. These are rule 14(2). Under rule 14. Sub rule 2. Eligibility criteria for the post of headmaster, superintendent in high school, stroke high madrasa, as the case may be, shall be as follows. He must be BA, BSc, BCom with BA degree from any recognized university. In respect of Hindi teacher having, this is not relevant for us. The second is important. He must at least 10 years of teaching experience as graduate teacher. Here, lordship, the petitioner has not completed 10 years of teaching experience as graduate teacher. He may have 20 years or more than 20 years service as a assistant teacher in intermediate skill lordship. That cadre is different and he is drawing lesser scale than the petitioner. Here, lordship, the one should receive the scale, graduate scale of pay. So from the date of receiving graduate scale of pay, the teaching experience.
When did you receive your graduate scale?
2018 in a service book. I have
2016, my lord.
2016.
Yes. Even you go by the 16, they also not completed. I have annexed the service book. The petitioner has annexed the service book. It is reflected, Lord. If your lordship please to take up the IA file by the applicant, I have annexed the relevant portion.
My lord, that aspect is, if my friend has completed, my lord, I'll reply, my lord. My friend complete, my lord.
And so far the review, lordship, it is passed also because the already impugn order is passed, lordship. That is also under challenge. And it is consensus order, lordship. Review of this order. So in my submission, lordship, there is no infirmity in the order. Number one. And secondly, in compliance of that review order, lordship, already the impugn order is issued. That is now under assail, lordship. And already there is a stay order. That is also operating. And for vacating of that interim order, I already have filed an IA. So lordship may take up today the review application. And this review application is not sustainable.
Yes, thank you. I don't.
And it is a consensus order. Lord.
Rule says about the, my lord, teaching experience of those teachers who are working in the high school.
No, read the rule.
My lord. My lord, page 36, my lord. So may kindly pay the second proviso of rule 14(2)(b). 36. Provided further that in case of amalgamated high school, where ME, MB school has been amalgamated, the assistant headmaster is eligible for selection as headmaster, subject to the condition that incumbents should have at least 15 years of teaching experience as a graduate teacher, including the period of service in the erstwhile ME, MP.
So in both the rule 2B and the proviso also,
My lord,
you should have 10 years experience or 15 years experience
my lord.
as a graduate teacher.
Yes, my lord.
That is the main thing.
Yes,
So when did you get your graduate teacher? When did you become a graduate teacher?
my lord, if your lordship, my lord, peruses the NCT notification, the in my lord, elementary school rules, my lord, there is graduate post of graduate teacher has not been defined.
When did you get your graduate scale?
In the year 2016, my lord.
Then we will count from that day.
Lordship may kindly peruse the amalgamation notification.
Where's-
Wherein my lord, it is specifically it is held that they will get the benefit of their past services. Page 98, my lord. Page 98, 11%, page 102. Page 102, clause 16, my lord. Clause 16. Gradation list. Each of the teachers shall be the teacher of the higher school after amalgamation merger of their status will be revised. After amalgamation merger, the graduation list of school or district, as the case may be, has to be revised by incorporating the names of teachers against the higher school in accordance with his qualification and status. She will get the seniority as before, and her name has to be placed in the appropriate place in such a way that she does not lose her seniority.
Ah, that is for seniority.
Yes, ma'am.
But for the criteria for appointment as headmaster,
As the elementary education service rules does not define the post of graduate teacher, Lordship may kindly peruse the provisions of the ROP, wherein the persons who are incumbent, who are having the graduate degree, they have been they have been marked as graduate teachers only. In the ROP, if Lordship peruses the ROP, I have given the abstract of the ROP, my lord, in that book, my lord, page 127.
this book,
Yes, my lord, 127.
127.
Yes, my lord. On 27, my lord. Assam School Service, Junior Teaching and Inspection. Assam School Service, Junior Class 2. This is formula high school. Graduate teacher of higher secondary high school, assistant so and so. Their pay scale is, my lord, 14,000 to 49,000. Pay band, that is, and grade pay is 8,700. That is in respect of, my lord, graduate teacher in high school. In the latter part, my lord, Assam Lower School Service, Teaching and Inspection. Here it says graduate teacher. Their pay scale is also same, my lord.
This is undergraduate.
My lord.
Undergraduate.
Graduate teacher, my lord.
No, undergraduate. Junior undergraduate teacher of ME, MB senior secondary schools.
No, my lord, last line, my lord, of page 127, my lord.
Okay, graduate teacher.
Yes, my lord. So I am enjoying the benefit, same pay scale, my lord.
And then you filed another writ petition.
Writ petition challenging his appointment, my lord, subsequent appointment, without taking into consideration of your lordship's order. because on the date when the order was passed by your lordship, he was under suspension. That fact was not placed before your lordship. That fact was not placed before your lordship while disposing of the writ petition. He was under suspension, my lord, at that point of time, while this order was passed.
Dekau, were you under suspension when the order was passed?
Lordship,
Were you under suspension?
that is revoked, Lordship.
When was it revoked?
Suspension order dated 26/7/2022.
That is immediately,
And the
Lordship, after-
order was passed by your lordship on 28/7/2022. After 2 days of suspension, this order was passed.
That is revoked, Lord. Subsequently.
Subsequently, it was revoked, but when the order is passed,
No, when the order was passed,
he was under suspension, my lord.
appointing him as the headmaster.
No, my lord. While disposing of the
Where is
writ
that
petition,
order? Where's the
while disposing of the in the review petition, your lordship will find that order, my lord.
in the writ petition?
Review petition.
Page?
Page 87 is the suspension order, my lord. Page 87 of the review petition, my lord. This was on, my lord, 26/7/2022.
This is 26/7/2022.
Yes, this
When was the order passed?
lordship disposed of the writ petition on 28/7/2022.
Okay. So 2 days prior.
2 days prior to the disposing
And
of the
when
writ
was it
petition.
revoked?
Subsequently, in the month of January, I think, my lord.
No, immediately after, Lordship, I have not bring the order, Lordship. Immediately after, because this is on different ground, Lordship. He is not responding to the senior.
When was it revoked?
That order is, Lordship. Let me. Next week, I will produce the order, Lordship.
Review has been preferred before lordship only on the ground that for counting the past service towards his, my lord, teaching experience. Nothing more than that, my lord.
Yeah, that is.
Revocation order?
But I will produce right now, but I don't have that order, Lordship.
Then you produce it.
Yeah, I will, Lordship.
We will give because I want to be very clear on this.
Yes, Lordship. I will produce that, Lordship.
But I cycle and it comes.
So, Lordship, so far the definition of graduate teacher. Lordship, kindly have the page 21.
No, that I've seen.
It defines, Lordship. In a high school, he should work in a high school. But admitted fact is that
But this
after
has,
amalgamation.
in the case of
he can
Miraram
be
Kumar, this noble court has already had.
Miraram Kumar is also, if I'm not wrong, Lordship, it is so far the graduate teacher of the ME school. Here it is a case, he is not a graduate teacher, Lordship.
Same plea was taken in Miraram Kumar.
Yes.
I was the arguing counsel in Miraram Kumar, my lord. I know that case.
Graduate teacher.
My lord, my argument was that, my lord, there is no graduate teacher in ME school, as no post has been defined in ME school. But this honorable court held that the persons enjoying the graduate scale of pay, they will be the graduate teacher and their past services shall be counted.
Who is the graduate teacher?
Page 21. It defines, Lordship. Graduate teacher means and includes the category of assistant teacher, classical teacher of higher secondary or senior secondary school or high madrasa or a high school, including amalgamated higher secondary, senior secondary and high school for whose appointment the qualification is so and so. So here admitted fact is that the school in question, the ME school, he was a teacher of a ME school. The ME school is amalgamated in the month of January 2018. So after amalgamation, he became the teacher of the high school. So since if we count the date of amalgamation 2018, he is not completed 10 years of term. And the rule is very specific, 10 years as graduate teacher.
Okay, heard this is I cycle and it's counsel for the review petitioner. Also heard it. Who's appearing for the school education? Also heard a Dekal and counsel for the response number 5. When do you want? Dekha, when can you produce it?
I think after a week, Lordship.
Okay. let's- 21st?
Well. Lordship. So challenging that particular order, I also prepared it, but it is there, Lord. On 30th of August 2022,
Okay.
I prepared a writ petition WBC number 5491 for setting aside that suspension order. That's may I read the order? This order was issued on 23rd of September 2022. Edeka Learned Council for the petitioner submits that the order dated 26/7/2022, that is my suspension order, suspending the petitioner which is impugned in this writ petition, has been withdrawn by order dated 30/8/2022, passed by the inspector of school. Petitioner therefore submits that he has instruction to withdraw the writ. So accordingly, that is placed.
Get a copy.
Yes. Obliged.
You can take your this book.
So far, the review is concerned. Lordship.
We'll
There's
take
nothing
up
is
together.
survived.
Yeah, we'll take.
Copy of the 30th order. It is related. Lord.
Item 1.
Yes, ma'am.
APSC?
Yeah, okay, okay.
Yeah, APSC. And okay. Parties have submitted the original arguments. Hearing concluded. Judgment is reserved.
Okay.
Obliged.
Timing item 34.
May I please, your lordship? This is a case, my lord, where the writ petitioner claim for, my lord, promotion to the next higher post of reader. As you have two folds of, my lord, prayer, my lord. One, for giving effect of his current promotion from the date of his qualification in terms of the rules. And second fold prayer is that, my lord, the next higher post, he should be promoted because under the rules, he is entitled to be promoted in the next higher. Same, this is a covered case. My lordship, kindly see page 39. In a similar circumstances, my lord, from same college, one writ petitioner approached this honorable court. This honorable court, after considering the facts and circumstances, allowed the writ petition. Petitioner belongs to same footing. The petitioner is in a better position because petitioner was appointed in 2006 as demonstrator, and this writ petitioner was appointed in 2009. Thereafter, present writ petitioner qualified his MDS degree. My lordship, kindly see page 43. My lord, page 43 table. Paragraphs 12, serial number 4, top, first clause. A reader who has completed 5 years so and so. Next, down below, my lord, lecturer with completed 5 years of service at the AGP of 7,000, annual grade pay of 7,000 subject to DCI guideline. Here is a case, petitioner case was recommended by the, my lord, principal of the Dental College Guwahati, as well as, my lord, director medical education has also forwarded his case, my lord. Principal has forwarded annexure 13, page 36, has recommended his case, my lord.
1 minute. Yes.
With reference to the subject cited above, I have the honor to enclose table 1, 2, and 3 herewith the list of teaching and staff and so and so And so next page is the, my lord, page 37 is the, my lord, position, vacancy position, my lord. Serial number 2, number of posts, 2 posts are vacant, 1 filled up, 2 posts is there, 1 filled up, Dr. Esha, and next is, my lord, vacant. Then, my lord, next page, page 38. Page 38, my lord. Director Medical Education has forwarded his case, my lord, subject regarding eligibility of promotion to the post of reader in respect of Dr. Deveshwar Das, present lead petitioner, lecturer of oral pathology and microbiology and forensic odontology, Regional Dental College, Guwahati. With reference to the subject cited above, I have the honor to forward an application along with enclosure in respect of Dr. Deveshwar Das, lecturer of oral pathology and microbiology and forensic odontology, Regional Dental College, Guwahati, as submitted by the Principal Regional Dental College, Guwahati, by under reference regarding eligibility of promotion to the post of reader against a vacant post at Regional Dental College, Guwahati. Dr. Das has passed MDS in 2017 and completed 4 years of services as per DCI norms. My lord. He has completed the requirement, my lord. The publication details are enclosed herewith. However, points acquired for publication as per DCI scheme is not mentioned. Next page is the judgment, my lord.
What is the response of the respondents?
They have not filed response, but it's a similar order I played.
Notice issued notice, lordship, in this case.
Notice issued, my lord. On 19/12/2022, my lord. Lordship, kindly listen. Notice was issued.
Notice issued.
Already, my lord, notice issued. My lord,
No instructions, lordship. But it is said that it is, I have seen the petition now. It is similar, lordship.
It's a cover case.
Then we
ma'am.
can dispose it.
Yes, lord.
Are you sure?
Otherwise, lordship may give me 2 days or 3 days time, lordship. I will-
Lordship can take up on Friday, my lord. She will come up with instruction.
Yes.
Okay.
Lordship
That
come up.
will be better.
What, Mr.
JMA Chaudhary.
J.M. Chaudhary, let me also put a petition. On request
D. Bora.
made by Ms. D. Bora, representing Council Health Department. List down. When do you want?
Friday, my lord. Day after tomorrow, it can.
Not day after tomorrow, lordship. Monday, lordship.
19th.
Lordship.
Timing item 37.
Appellate, your lordship. This will be to Madam Minister.
Both
Here.
sides are ready?
Pleadings are ready. Because already they have filed affidavit. I don't want to file because it's a matter of policy. That is why no need of filing condition. Your lordship will not need satisfaction to your lordship only required now. Here, my lord, first and foremost issue involved here, the petitioner was selected and offered appointment by the respondent ONGC for the post of junior technician in Assam zone under reservation of benchmark disability category for hearing impairment having 50% disability. That is his having. Though offer of appointment was issued by Chief Manager, Human Resources Department of ONGC, but thereafter he has to go for normal medical checkup. While going for medical checkup, this concerned doctor, he has gone beyond limit that you have submitted the disability certificate, which is valid up to 25/5 of 2025, next year. That is why approval was not given. This medical officer, concerned medical officer, was to give disapproved. Neither disapproved nor signed, he has not signed. That is why he is unable to join in service. That is the main issue of this case. Now I'll take your lordship. Now, as a very recent list of dates, I've given your lordship. 2/6/2021, the petitioner passed and awarded national test certificate for mechanic diesel and SQF by the Ministry of School Development and Termination Direction, page 4, which is basic qualification required for this post. He has that. There's no doubt in that. The 25/5/2022 disability certificate issued by medical authority by Shivsagar, District Shivsagar, Assam, certifying hearing impairment of 55%, temporary disability up to 25/10/2025 below. That is also fact. Now, there was an advertisement by the ONGC for various posts, non-skilled posts, Millard, that is zonal wise. Then particularly for Assam zone, we will get in Annexure 8, page 36, Millard. Lordship may now turn into this. Lordship, where we start from this one. Here another point, no dispute, Millard, because regarding certificate. The Annexure 8, recruitment to the non-executive in ONGC, that is page starting from page 31, Millard. This is online form was to be, that is important, online application form was to be submitted from 7/5/2022 to 28/5/2022, Millard. And post which I applied, Millard, Lordship will take it to page 36, Millard. Lordship got it, page 36. Here you will, Lordship, see A8 ONGC work centers in Assam. That means this is for particularly Assam zone. Now, Lordship, I'll take to last serial number, that is 15. Junior technician diesel. Now, 2 posts are reserved for bench identification for benchmark for this disabled category, Millard. Here, 2 posts are for here hearing. Category B, hearing, Millard. That is for impairing of hearing. Now, my lord, another aspect is to be seen. What are note for candidate? While filing, they have given some notes. What is to be followed? Lordship got it. Page 41, my lord. What is to be followed? Notes. Lordship got it. That is G notes for candidate. Lordship got it. Here, right side, if your Lordship get it, 18, Roman 18. Lordship got it. That is important. I have given here a brief also. For persons with benchmark disabilities, this is marked. Certificate disability should be issued by the notified medical authority in the format prescribed in the Rights of Persons with Disability Rules 2017. The minimum degree of disability of a person to be eligible for any concession benefits would be 40%. Now minimum requirement is 40%. That certificate is to be issued under the provision of this act, because though it is an act, rules 2017, my lord. Here, my lord, we will go by, here, Lordship, again, I'll take back to this certificate. Again, I'll take back to your Lordship. This disability certificate, page 29. Lordship got it. Name, first paragraph is name of the petitioner, Ankit Chaikia. A, his case is a hearing impairment. The diagnosis case is hearing impairment. He has 55% temporary disability relation to his ears as per guidelines so-and-so, PWD Act 2016 notified India so-and-so 76 2004 2018. And this certificate then recommended for 3 years, 5 months. Therefore, the certificate shall be valid up to 25/10/2025. Now, as per requirement, their own requirement, this certificate been issued, Miller. Though it is an act, but issued are given on the basis of rules. Rule 18. What Rule 18 says, Miller? Issue of certificate. 17 is this one. Application of certificate. Lordship decision. Right to persons with disability act. That is it. Neither did my dear sir. আচ্ছা না আচ্ছা ভালো
Rule.
Lordship, got it. Same book, I think, na?
Yes.
Lordship, page 58 and rule 18. Got it? Rule 18.
Page 58.
Page 58 of my book, this is Bare Act of Law and Justice, this book, Law and Justice. I think
Rule.
Rule 18, Miller.
Oh,
Issue of certificate disability. Lordship, got it.
yes.
On receipt of the application under Rule 17, the medical authority or any other notified competent authority shall verify the information as provided by the application and shall assess the disability in terms of the relevant guideline issued by the central government, and after satisfying himself that the applicant is a person and disability issue certificate disability in favor of form number 5, 6, 7 as the case may be. The medical authority shall issue the certificate disability within a month from the date of receipt of the application. The medical authority shall, after due examination, issue a permanent certificate of disability in cases where there are no chance of variation disability over time in degree of disability, or, now this is important, issue certificate disability indicating the period of validity in cases where there are chances of variation over time degree of disability. There is a provision. They are giving this one. Now the application found eligible issue certificate disability cover, this will be, accordingly it has been given. 19-year-old lordship will see. There's a provision. Either permanent can be also given, and if it is variation, they can give temporary also. Temporary also they can give for a time period. Now next, 19. Now this certificate 19 you will see, certificate issued under Rule 18 to be generally valid for all purposes. A person to whom the certificate issued under Rule 18 shall be entitled to apply for facilities, concession, benefits, and for persons with disability under the scheme of the government and non-government organization funded by the government. Here, this our certificate is issued as per this provision. There's no doubt in that. Because my learned friend who is appearing on behalf of medical, they have also clearly said, yes, we have issued as per provision of law. There is no doubt in that. But here, my lord, in advertisement, when I have tell you benchmark notes for this one, just now I have read Miller, it is nowhere mentioned that if you temporarily get, you will not get the appointment. You will not get the appointment, nothing is mentioned. Only here point is there, if certificate issued under this provision, you have to be given under this provision, you have to be this. Meaning their way, they are not, once they have not mentioned, they know the Rule 18, there is a two provision that can be given permanent, or where the diseases are like similar, hearing and the first time they do not give, they give for valid for some period, thereafter second time, they give. That will come later on, my lord. This is no. Now, second point will come. As per this, nowhere is mentioned. Now I have appeared. Next moment, I have applied accordingly. Now, my lord, as I have said, nothing is mentioned. Now, 10/8/2022, date of interview, the petitioner was issued. He admit card. Accordingly, he appeared in interview. I appeared in interview, my lord. Now, 10/8/22, or that is 11/1/2023, my lord. As the petitioner was qualified and shortlisted, I was being shortlisted, qualified. Under category document verification was carried out. 11/1/2000, my document also has been verified. All documents, here it is there. So we have to put all documents because it is a online application. So we are required to produce all original documents. Whatever we have mentioned, we have accordingly produced. Document verification was cleared up. Now, 11/1/2023, document verification was carried out. 16/5/2023, issued an appointment order to me. 16/5/2023, I issued offer of appointment. Offer of appointment is issued to me. Now, by 22/5/2023, when I have gone to medical officer for generally what happened, all services, he has to go for medical. Now, that party officer concerned, I think it has gone beyond limit. Because one certificate been issued by the board, board, there is members, chairman and members. He is asking you bring it now. You bring permanent. Will not accept it. Whereas nowhere it is earlier mentioned that if you in advertisement, nowhere it is mentioned that this if it is temporary, will not allow. Because there only one point is there, if your certificate should be under the provision of law, that is Act 17, Rule 16, Act 17. That was the point. Nowhere it's mentioned. Now, they are not issuing me. No. They are not giving happen. Now, I have not concealed any documents. I have produced all documents during verification. After verification, that is manager racer, who is the top boss. Human Resource Department is chief, after director, chief manager is the main. He is the main officer. Only he has told you have to go for medical checkup, you have to go for. And then we have gone. Now, before your lordship, now question is coming. Now affidavit has come up from the respondent authority. That
Let us see that impugned order
impugned order.
that refusing you.
No, refusing is, yes, that is fair. Then the impugned order, last page, my lord. I have extended, prayed for time. Page, lordship will get it here. Here, lordship, page 63. Here, I was verbally asked to produce documents, permanent certificate you produce. Yeah, my lord, here lordship got it. Now I have prayed for time to, because I have to go, was being helpless. I took time to what to do. Then I went to medical officer also. That's why here lordship will get it. Lordship got it, I think, last page. Page 63, my lord. Here only, in the extension joining date has been granted till 29/6/20 as requested by you, Valley trailing mail 1660 as communicated by the email 2060. You are again requested to produce permanent disability certificate as per the guideline on the subject prescribed format permanent 29/6/20. In case you fail to produce the required permanent disability certificate by 29/6/2023, the offer of appointment so and so dated 16/5/2000 is automatically and without reference stand cancel as noted this one. This is to be cancelled. Then immediately I have asked to this honorable court, our honorable court, please to admit the case, this case, and interim protection is granted that that post may be kept reserved, to be kept vacant. This is the stand now. Now question is coming, my lord. They are telling permanent certificate, you give me permanent disability certificate. Now my learned friend has given affidavit, a very short affidavit. May I read, my lord? Lordship will get it. When? 70? 78. What is it? Yes, 70. Yes, starting from 77, my lord. 78. Relevant is 79. Okay. Starting from this one, lordship, may I read? Lordship got it. Paragraph 3. The ensuing deponent based to state the as per record available in the office of the undersigned disability certificate in respect of Ankush Saikia, which was issued by certificate AS number so and so 25/2022 against the case of hearing impairment with 55% temporarily disability as per notification of Ministry of Social Justice and Employment, Government of India. It is pertinent to mention herein that as per clause 4(3) Roman 1 and Roman 2 of the notification dated 30/12/2009 issued by Ministry of Social Justice and Employment, it is clearly stated that a permanent disability certificate can only be issued in cases where there are no chances of variation over time, the degree of disability, and in case where there is any chances of variation over time in the degree of disability, the period of validity in the certificate shall have to be indicated. In view of the above, it is respectfully submitted that certificate in respect of Sri Ankush Saikia has been recommended by District Disability Board Chichagar for 3 years, 5 months, and the same is valid till 25/10/2005. Full stop. After expiry of the validity period, the petitioner Ankush Saikia will have to apply through online as per guideline, and thereafter he will have to appear before the board for proper reassessment and board will decide the issuance of permanent certificate accordingly. This is their stand. Now, their stand is that we can give after 25 decision. Their stand. Now, ONGC is saying, no, you bring permanent certificate. Whereas I have not done anything or not concealed anything. I'm duly selected and appointed, a power of appointment was issued. And no clause nowhere it is stated as a temporary. If you are temporary, then you will be not given gradation. Now, my humble prayer before Lordship, there is a, only this is my feeling and suggestion, my Lord. Because now they are fighting and I'm been in between. I have come now. I am the affected person. As my validity up to 25, there is no doubt. There 40% is required. I have 55%. There is no question and there is no doubt in that. Either they may give me up to 25, and thereafter, if suppose my percentage goes down beyond 40, I'll be thrown out from service. That is the provision. Either again, because when I have applied under the provision of Act, I'm being issued certificate. That certificate, dear Lordship, I have gone through. That there is a provision for permanent also, temporary also. Next very clause, rule 19 say it is valid for all purposes, all services. And advertisement also it is not mentioned. During verification time, they would have rejected my petition. Okay, your certificate is temporary, but they have not rejected me, Lord, during verification. Thereafter, after verification, I was a power of appointment.
Where's that advertisement? Let us see again.
Pardon?
Advertisement.
Advertisement, Lordship, I'll take back to your
Page 20.
page
20.
Well, let's page 31, advertisement. Lordship got it. Relevant is, advertisement is.
From the advertisement, page 31, second para is very important. The heading, and bold letter candidate can apply for the post of respective state as per their status of domicile, permanent residence of the state, subject to meeting of their other eligibility criteria. As department candidate can also apply for the work center filling in any state respectively, their status of domicile, permanent resident. So far eligibility is concerned, at the time of, this is online application, at the time of filling of online application, it is the responsibility on the part of the candidate that he has submitted the required document. And that apart, page 44 of the advertisement, page 44. Down below, general instruction P, serial number P. All applicants must fulfill.
Page number?
Lordship found, all applicants must fulfill the essential requirements of the post and other conditions stipulated in the advertisement. They are advised to satisfy themselves before applying. No inquiry as to for advice as to eligibility will be entertained. Their admission, all stages of the examination will be purely provisional. May issue of admit card, call letter, or skill test, etc. to candidate will not imply her candidacy has been finally cleared by Wednesday. So far, in the beginning, my lord, while applying, so far the documents are concerned, this is the response on the part of the applicant.
No, what does your advertisement say about the disability certificate?
Yes, ma'am. Yes, ma'am. That is here, my lord, from once page 41. My lord, that just now has been read out by the Senate Council, my lord. Note for candidates. Note was Z, my lord. Page 41 down below 18. For persons with benchmark disability. Certificate is as per the Act, This is the Act, Yes. 40% disability. Right of persons with disability, 2016, man. That is there. This is a rule under, rule is framed under Right of Persons with Disability Act 2016. Rule is 2017. Now, my lord, from the act, my lord, may place that, my lord, one section, definition of persons with disability, my lord. My lord, section 2S.
Act.
The act, my lord, yes. S, my lord. Yes, my lord. Persons with disability means a person with long-term physical, mental, intellectual, sensory impairment, which is in interaction with the various hinders his full and effective participation in the society equally with others. My lord, there is an expression long-term long-term disability. The disability, my lord, as per this, my lord, here the problem is that this certificate is to be a particular date, 25/10/2025. After what will do, my lord? So, no. So, that certificate also indicates this is temporary. His disablement is temporary, that the certificate, my lord, is also provides that temporary disability.
Yes, there is no doubt in that.
So, and temporary disability up to the period cutoff date 25/10/2025. But the expression of the act that so far disability is concerned, it should be long term, there meaning there with a permanent disability. However, such the long term disability as per 2R, my lord, person with benchmark disability, this is quantified at least by 40%, but not for temporary. 40% with permanent or long-term disability, where no date will be mentioned. Now, my lord, the rule provides under frame under this act, my lord, Rule 18. Rule 18 deals with issuance of disability certificate. Now, under this rule, my lord, there is a format, form 5, my lord. In the rule, my lord, there is a form, my lord, how this certificate is issued in case of, my lord, disability. And this is permanent, my lord. Kindly see, my lord, form 5, my lord, lawsuit found, my lord, Roman 5. Lawsuit found, my lord.
Yes.
In cases of amputation or complete permanent paralysis of limbs or dwarfism, and in case of blindness, my lord, name, address of the medical authority, this is the format, and there is no date fixed up to which date. My lord, here, this is the format under which the government in the medical department has to issue, the competent authority has to issue the certificate. So, as per the provision of this act, my lord, the authority asks him to produce the permanent disability certificate.
What about Rule 232?
My lord. Rule 3.2, my lord.
Rule 18.3.2.
Yes, yes. Yes. Sciences of variation. Yes. 18.3.2, my lord. My lord, here, my lord, the disability indicating the period. My lord, here, in a case where there is a chances of variation, my lord, in a case where chances of variation is there, then they will not issue permanent. And this is the affidavit they have stated. Here in this case of the petitioner, so far the impairment of here is concerned, there is chance of variation, and therefore they have given a date. And on that date, he will has to.
Exactly.
Yes, my lord.
So practically,
My lord.
normally hearing and all the chances of variation.
Yes, my lord. He can recover also.
He may recover, he may not recover.
My lord.
So when he goes and applies on, in 2025
Right.
for re-checkup or a re-verification, if they find that no, it has not improved, then they'll offer, give him the permanent disability.
My lord.
At once, they cannot just give a permanent disability unless it is a very serious nature. So,
My lord, therefore, my lord,
so when the rule provides,
yes.
can you go against the rule?
No, I cannot, my lord.
Then,
I cannot.
then
But-
why can't you give your appointment at least up to 2025?
Yes,
My lord, that's correct. In such cases, my lord, this post, it will affect to a person who is a permanent disabled because this post has to be.
Supposing in 2025 he goes and have a checkup,
My lord.
or have a verification
My lord.
again,
My lord.
and they give him a permanent disability certificate, what happens to him?
So therefore, my lord,
What happens?
but
If the certificate issued in
Yes.
2025
yes,
is below 40%,
my lord.
then you can throw him out,
Yes.
right?
My lord,
You
so-
can throw him up,
Yes.
fill it up, post with another person with disability.
My lord.
But if he brings a permanent disability certificate, what happens to him?
My lord, in such cases, this is the situation in a case, my lord, in the division bench has decided this issue, my lord. Whether certificate is required or filling of the post under disability quota is of permanent nature or temporary. So in such case, this is the judgment passed by the division bench of Punjab and Haryana, my lord. Here it is, my lord, has been held that so far the certificate for filling of the post under the PWD quota, my lord, it has to be a permanent disabled certificate. On temporary disabled certificate, this no appointment can be given, my lord. So this is, my lord, by a division bench, my lord, and it is in by reading the, my lord, section 2S along with section 18 also. So far, where in a case of, my lord, review is concerned or reassessment is concerned, my lord, then in such cases, the Honorable Court has not said that since it is not permanent, so he cannot claim for it. I may please desist.
Before going, judgment will
This
come
is a
later on, my
question of
lord.
law, my lord.
Question of law, whether facts and law runs together. What for this case was there, first and foremost, this honorable court is not, as my mind is not bound because it is not Supreme Court judgment. That apart, whatever fact is there, is it similar? We have to go by law, my lord. Once before your law is available, rule is available, law is available, by it is a enacted law is available. This is, we cannot say what this one, we do not know what is about facts and facts kya hai, facts ki, what is the facts, what is the law, what is, we do not know. That will not come. Once before your lordship, let him probe, let him give one decision that we have given clear cut. There, according to them, that you have to bring the disabled certificate as per provision of law, that is Rule 17, which is rule is came under Act 16, my lord. Now, as per Rule 17, it is been given. They had only this much 40% required. They also know that there is a 3 point in 18.3.2. There is a 2 provision. It can give him permanent or temporary also it can be given. It is their bounden duty. If you, this one in case of 18.3, though you are bringing the certificate, but if under provision of 3.18.3.2, as per Lordship pointed out, if you're temporary, will not accept. But very next rule says it is applicable for all. Now, can he go beyond the rules and law? Can he go beyond it? So by showing one judgment of Punjab and Haryana High Court, we do not know what is the facts said there. What is the facts at this one? We do not know. And where is it before your lordship? Law is available, act is available.
I will provide one copy of the judgment to my friend.
No, I do not want because it is you give to provide to your lord. Provide to your lordship.
In principle, my lord, we are arguing the case, my lord. If today this will happen, my lord, that temporary having a person with temporary disabled certificate, if it is to be, my lord, considered, then tomorrow in the subsequent, my lord, advertisement,
No,
we have to face the problem because we have to consider those person with temporary disabled certificate. So, my lord, so for this matter is concerned, the temporary certificate having not been considered for appointment, considering appointment under this quota, my lord, and he assured before the authority, lordship, in the impugn order that has been shown page 63, he filed, submitted one mail, my lord, that I will produce 13/6/2020, that I will produce the permanent disabled certificate.
Because
And my lord, the advertisement, last date of advertisement is 28/5/2023. The date of certificate is 25/5/2023. Just prior to 2 days, my lord, this certificate has been obtained.
whether disputed,
That I do not dispute. And
you disputed.
had that there been the, what is not there, the temporary, then tomorrow it will be claim of the thousands percent in the subsequent advertisement. This is our problem, man. Because the certificate page 29, it is very clear, has 55% were temporary disability. Lordship found, my lord, C, my lord, he has page 29, serial number C, he has 55% temporary disability in relation to years as per the guidelines and disability period 2016 notified. This certificate recommended for 3 years, 5 months, and therefore the certificate shall be valid up to 25/10/2025.
Yes.
His certificate is having a validity cut-off date. So, my lord, perhaps this is not the case. A certificate with temporary disability, wherein it is very clear from the certificate itself, my lord. So, otherwise, my lord, our problem is that, my lord, tomorrow there will be the havoc, my lord, on
Yes.
temporary certificate.
In
And
this
this,
point.
my lord, so far this judgment is
Practically,
concerned.
all the medical boards, they
Yes.
issue temporary certificates at the initial stage.
Yes.
My lord,
And thereafter, on the next date,
Mm.
they are given the permanent disability.
my lord. And so
Now,
far, my lord,
can you just throw the candidate
yes.
because he can't produce a permanent disability certificate?
My lord, therefore, I was placing that, my lord.
Therefore, this court has put a suggestion.
Yes.
Why can't you give him appointment up to 25/10/2025 with a rider
Yes.
Yes.
that if he's in the next disability certificate, if his disability comes below 40,
30.
My lord, yes, my lord.
then
Sir,
he will have to go out.
my lord, I will get instruction on this, my lord.
Then you take instruction.
I will take, my lord. And moreover, one submission, my lord. From the form number 5 of issuance of disability certificate, my lord, so far hearing impairment is not there in enlisted. Because hearing impairment, one person having hearing, he cannot get permanent disability certificate. And the person of hearing disabled man, so having sons of, my lord, variation, therefore he will not get a, is in case of deface, one hand has gone, one leg gone. In such cases, my lord, it is a 40% or 60% disablement. It's a permanent deface. Here, my lord, hearing, and therefore, this imprisonment, my lord,
See, it is not for this court.
yes.
that
Yes.
Who is to be given the
Yes.
disability certificate or not?
Yes.
The experts
Man,
Board.
who are sitting in the medical board,
man,
they have considered and they have issued the certificate.
man.
Yes.
There's nobody to
Yes.
ask them the question.
And
And they have, my lord, on his assurance, we waited for them.
yes.
That, my lord, and then, my lord, the government has said, we cannot issue.
No, they did not say we cannot issue.
Review.
They said when they come next, they will
Yes.
see. and
Next day
consider-
we'll
and
consider.
Consider whether he will be issued
Mm.
the permanent certificate. That's what they said.
Yes.
Or-
They said that they will not issue.
Yes, my lord.
Yes, my lord. Or, my lord, can it be like that, my lord? Because if once it is appointed, my lord, it will be difficult, my lord, for removing one person, my lord. There will be cases. after
Rider,
that,
rider will be there, my lord. Court's right.
Let
Order
me
will be
come.
there.
Let you take instruction.
Yes.
So in such cases, my lord, let him appear before the authority, my lord, with a prayer for, with a request for issuance of permanent certificate, and they will reassess, my lord.
No, no, no.
Verify.
It's already clear said.
So-
There's no provision. How, why they will go unnecessary?
You just take the instruction.
I will.
Let's see what all and come to the petition. Mr.
B.K. Das.
B.
B.K. Das.
B.K. Das. You're the standing counsel?
My lord, yes, my lord, counsel for bench.
General counsel for the respondent one shall receive instructions. Stop. When do you want?
Next week, Miller. Only
10 days,
instruction is
10
to be
days. I will email them and they will get it from Delhi, my lord.
21st.
obliged.
Obliged.
That should be clear, Miller. That
I will get
in
it.
in regard of what he will take.
Obliged.
Item 47 for orders.
My pleasure. My pleasure, Lordship. The matter has become infructuous. We have already complied with the order.
You complied with the order?
Yes.
But where is the petitioner's counsel?
Serial number 15 out. Thomas Daimari.
Let us wait for the petitioner's counsel and give them one chance. If they don't come, we'll dispose it. None appears for the petitioner. MS
G. Swami
G. Swami,
on
learned
behalf of A. Sharma for
Counsel.
Assam Clean Pipes Development.
appearing on behalf of Mr. A. Sharma, learned standing counsel, Assam
Assam Clean Pipes Development Corporation Limited.
Development Corporation has produced a communication dated 3/11/2023 and submits that the respondents have complied with the directions passed by this court. Stop. But however, as the learned counsel for petitioner is not present today, list again on, I'll give a date. 26th.
Obliged.
48. The communication dated 3/11/2023 is placed on record.
48.
May I please, Your Lord?
Yes.
Lordship, the contempt petition for non-compliance, the order dated 23/11/2022, passed in 7/4/62. Operative part is on 29, Your Lordship, page 29.
Who appears for the respondent?
I'm appearing for the respondent number 2. We have received instruction, we'll file the affidavit.
1 minute, 1 minute. Yes.
We have received the instruction.
What instructions have you received?
So far as respondent number 2's role in this is concerned, my lord, we have communicated to the director non-formal and adult education. We have asked them to sanction the amount, and as soon as the funds are received, we will pay the honorary as directed by the honorary.
Who appears for the respondent one? Have you taken steps?
Yes, Your Lordship. One Appearance was made here. For one. Yes. That's true. Oh, none appear, your lordship.
Nobody has filed
No,
any wakalat.
nobody has filed. Step was taken here.
You have to take first steps. I think this is the respond number one. He is the main respondent.
Then I will take first step.
Okay. Mr.
R. M. Mazumdar.
R.A. Majumdar, learned counsel for the petitioner. Praise for taking first steps on the respond number one by registered post AD within 1 week
Yes, sir.
from today. Stop prayers allowed. Stop. Mr.
U Sharma.
U. Sharma, learned counsel, enters appearance on behalf of respond number two.
Two.
Stop. List after 4 weeks.
Your lordship,
Obliged.
they may file affidavit in the meantime.
Yeah, they can file.
Obliged.
Obliged.
49.
As per the order dated 19/1/24, passed in IA Civil 65 of 24, my lord, the respondent number two's name has been implemented. We have to take steps, lordship, if direction.
Respond number one. No, number two.
Number two, sir. The IA was allowed on the last occasion. We have amended the court.
Okay. But Mr. B. Bharatwaj, learned counsel for the petition. The petitioner has filed the amended cost ID. Stop. Petitioner to take steps for service of notice on the respondent number two by registered post AD within 1 week. List after 4 weeks.
Okay. 50. Lordship, as per office note dated 29/1/2024, Lordship, in respect of service of response 2 3, Lordship complete. Lordship, in respect of response number 1, neither etiquette and nor answer notice has been returned back, Lordship.
1 minute. How about 4?
Whole Lordship, they have given a letter to the registered Lordship saying that they are not the necessary party here in this. Lordship, they are the finance department. Finance was the made party in the writ petition, Lordship. If
Finance was a party?
a party in the writ petition, Lordship.
Where is the judgment?
At page 24, Lordship. Response 4 was the finance department, Lordship.
Yes, you are appealing for?
I'm appearing of the peanut.
2 and 3,
2
Lordship.
and 3. My lord, we have received instruction. Kindly keep us at the file.
What about 1? You want to take first steps?
Yes, Lordship, in respect of 1, we should wait for, because the AD card and answer notice has not been written by Lordship. Otherwise, in respect of respondent 1, the office of respondent 2, I think, Lordship, they have communicated with respondent 1, Lordship. There is a letter, Lordship.
On 13/9/2023, notice was issued.
Yes.
Till now, nothing has come. You take first steps. Heard, Mr.
Yes, Sutradhar, Lordship.
Yes, so and so for the petitioner. Petitioner to take first steps for service of notice on respondent 1 and 4.
1 and 4. Whole Lordship, they have written a
Whatever
letter.
it is, you take steps.
Yes, Lordship.
First steps. Okay, respond number 1 by registered post AD within 1 week from today. Stop. MS.
Asumi. Asumi.
Asumi. Legal counsel appearing on behalf of Mr. D. Nath. and disappearance on behalf of respondents 2 and 3. Correct. Stop. List after 4 weeks.
51.
Met to your watch. Also, will kindly turn to page 12, my lord, of the contempt petition.
Yes.
Para 7, small para, I'll just read it out for your lordship. Para 7. Admittedly, in the instant case, as the memorandum of charges charge sheet have not been served upon the petitioner, and the period of 90 days have already expired from the date of intimation to the appointing authority, which was on 11/1/2022. This court is of the opinion that further continuation of the suspension of the petitioner would be in violation of the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary Chopra. Accordingly, this court therefore directs the respondent number 3 to forthwith reinstate the petitioner on the basis of a certified copy of this order being served upon him. And next page, my lord, we have served the certified copy on 27/3. This order was passed on 17/3/2023. We served the certified copy on 27/3/2023. Almost 1 year is going to be lapsed, still not reinstated.
Yes.
We have received an instruction in the month of November. Lordship. In this instruction, there says that the matter is under process and decision will be taken shortly. Thereafter, we have not received any instruction.
This is February.
Lordship. Yes, this is February. In the month of this instruction is we have received on 16/11 Lordship. We have to
So
take
15 from 15/11 it is under process till now.
Lordship. That's why we have to take instruction first that they have taken place.
Or we call personal appearance.
Lordship, that is true, but sometime maybe granted.
I'll give you a week's time. No.
The person concerned is on leave, Lordship. Question number 1, sole respondent, Lordship. The sole respondent is on leave, Lordship. That's why I'm praying
For how many days?
Lordship, 3 weeks, that's why I'm praying, Lordship.
I'm not giving you 3 weeks. If he's on leave, also tell him to come.
Lordship.
This is a contempt.
Contempt.
For reinstating one person,
Right.
you're taking 1 year.
Lordship, we have a written letter thereafter on 12/12. No instruction has been received till now.
Then we'll call him.
Lordship, for the of justice, Lordship, some time may be given. Lordship. His son marriage ceremony is held. So that's why he's on leave.
Hart J. Batwari, learning counsel for the petition. On request made by Mr.
Yes, Doctor.
S. Datta, learned counsel for the sole respondent. List the matter again on. When do you want?
In the month of March, Lordship. In the meantime, maybe
4th March.
4th of March. Obliged.
Deeply obliged.
52.
Lord, here I have filed a interlocutory application for vacating the order of stay granted in favor of the writ petitioner. But the applicant herein, that is me, is the first legally married wife of the deceased government servant. And the person who has filed the writ petition is the second wife. He has admitted in the writ petition, there is no dispute to the fact. But in the writ petition, he has prayed for a pension for her minor child, their daughter, who is 17 years old. So if I may take your lordship first to the interim order passed by this honorable court on 2/1/2023, which is here in page number 13 of my interlocutory application.
Page
13, my lord.
Yeah.
The relevant portion, if I may take a lordship to page 15. Paragraph 5. The petitioner Srimati Purabi Saikya Mahanto is admittedly the second wife of the deceased employee Niripen Mahanto, who was serving as Deputy Director of Agriculture at North Lakhimpur, died in harness on 13/12/2012. On his death, the family pension is being paid to the respondent number 8, Srimati Bulumai Mahanto, There is some error, my lord, in the order. The no pension has been paid to me, that is Bulumai Mohanto, since the death of my husband, because of the objection being raised by the second wife that she is entitled to the pension, who is admittedly the first wife of the deceased employee Niripan Mohanto. The second wife, Srimati Puravi Soikia Mohanto, has filed this writ petition on the grievance that her children to the deceased employee Niripan Mohanto, namely Sri Jenny Mohanto, would be aged approximately 23 years as on today, and Srimati Bhargavi Mohanto, who would be aged approximately 17 years as on today, are not being given the benefits of the family pension benefits by the respondent number 8. We are not expressing any view on the claim of the son Sri Jenny Mohanto, who is presently aged approximately 23 years, but in respect of the daughter Srimati Bhargavi Mohanto, who is presently aged approximately 17 years and is unmarried, would definitely be entitled for benefits of the family pensionary benefits under Rule 140 of the Assam Services Rule 1969. Although under the said rules, family pension would be payable to the eldest of the serving widow, that is the respondent number 8, but it has been held by this court in its judgment and order dated 22/12/2022 in Readypel number 160 of 2018, wherein it had been provided that the eldest surviving wife is paid the family pension as a trustee for benefit of all the other children of the deceased who may be entitled to the benefit of the family pension. From such point of view, if the respondent number 8 is not giving the benefit of the family pension to the minor daughter of the deceased employee Niripan Mohanto, their prima facie appears to be breach of trust by the respondent number 8. Therefore, on a prima facie case being made out, and in order to expedite the matter, we direct that until further orders, family pension be not paid to the respondent number 8 in respect of the deceased employee Niripan Mohanto. Upon appearance of the respondent number 8, further consideration will be made as to what orders are necessary in the present writ petition. But this order was passed in the year 2023, 2nd of January 2023. And in view of this order, the department has stopped the process of payment of pension, which is available at page 21. It is under the subject, stop payment of family pension in respect of Srimati Bulumai Mohanto late so-and-so. Reference Honorable Guwahati High Court Interim Order dated 2/1/2023. Sir, in inviting a reference to this office number so-and-so, issued in favor of Srimati Bulumai Mohanto, Agriculture ex-Deputy Director Agriculture, I am to state that as per the Honorable Guwahati High Court Interim Order dated so-and-so, it is requested to stop payment to Srimati Bulumai Mohanto until further order. Well, the pathetic condition of the petitioner is there, applicant is there, my lord. Since the death of her husband in the year 2012, she has not been receiving any pension because of various objections being filed by the second wife before the department. And department had to resort to a legal opinion from their legal luminaries as to whether the second wife is entitled to the pension or not. Well, after the problem was solved by some legal opinion, the department initiated the process for payment of pension in favor of the applicant herein. And to that effect, the respondent, the writ petitioner herself filed an NOC, no objection certificate before the department, saying that she doesn't have any objection if the pension is issued in favor of the applicant herein. That is the first legally married wife. Well, as per the pension rule of 1969, the eldest surviving widow is entitled to receive the pension. So far as her claim is concerned, that her children is entitled to receive the pension, but there are some decision of this honorable court, even in the Supreme Court in the year 2002, in Rameshwari Devi judgment, the Supreme Court has held, relying on section 16 of the Hindu Marriage Act, saying that the son or the daughter from the second marriage, though they are illegitimate, but they are entitled to the property. Pension being a property, as per the Constitution, Article 31, the son or daughters from the second wife are entitled to the property. And on that basis, the Supreme Court has held that the son and daughters through the second wife are entitled to the family pension. I have no objection to that decision and to that legal ratio laid down by the Supreme Court as well as our High Court. But in the full bench decision of this honorable court, if I may take a lordship to the full bench decision passed by Honorable Mr. Justice Bujor Borua, in the full bench decision, the copy of the judgment is available in the record, my lord. I have submitted, this was reported in 2023 1 GLT 736.
Yes.
2023 1 GLT. Well, there the issue was the division bench was confronted with two decisions of this honorable court. One is Surya Sultana and another one is Sirajan Nessa. In the Sirajan Nessa, one of the division bench of this honorable court held that the second wife is entitled to the family pension as the first wife. But in the Surya Sultana, the division bench, one of the division benches held that the second wife is not entitled to the family pension, though she is a Muhammadan or Hindu. But the children through the second wife are entitled to the family pension. But there is a bar in the family pension rule 1969 that two pension paper order cannot be issued in favor of two persons of the family. So if I may take your lordship to the relevant portion of the judgment, elaborated from paragraph 19. Your lordship has got. A conjoint reading of note 1 to rule 143.2 and rule 143.3 of the pension rules of 1969 makes it explicit and unambiguous that the family pension would be payable to the eldest of the surviving widow in the event of there being two or more widows. And further that even if there are minor children who may also be entitled to the benefits of the family pension, the pension would be paid to only one member of the family at the same time, where at the first instance it would be paid to the eldest of the surviving widow, and thereafter on her death to the next surviving widow, if any, and in its absence to the minor children. As a corollary to the provisions of the Rule 143.3 of the Pension Rules of 1969, Note 1 to Rule 143.2 would have to be read to mean that the family pension would be payable to the eldest of the surviving widows in the event there are two or more widows. And thereafter on her death, it would be payable to the next surviving widow, if any, and thereafter to the minor children if the occasion arises. In the circumstances, the concept of the validity and acceptability of the second marriage, where the parties are governed by the Mohammedan law, and the consequential entitlements to the benefits of a family pension, and the concept to whom the family pension would be payable under the pension rules of 1969 are held to be two separate and unrelated concepts, and the implication of the concept of the validity and acceptability of the second marriage or further marriages where the parties are governed by the Mohammedan law would have no bearing on the concept to whom the family pension is payable under the pension rules of 1969. It is held that irrespective of the validity and acceptability of the second marriage or further marriages, where the parties are governed by the Mohammedan law, the family pension under Rule 143 of the Pension Rules of 1969 would be payable to the eldest of the surviving widow, which would also be applicable for a family pension where the parties are governed by the principles of Mohammedan law, and where there may be a validity and acceptability of the second wife or further wives in respect of a second deceased Mohammedan employee. We further hold that the family pension being payable to the eldest of the surviving widow or wife would not mean that the entire family pension so payable would be the personal property of the eldest of the surviving widow or wife, and thus family pension so payable would be held by the eldest of the surviving widow or wife as a trustee for all such other persons who are entitled to the benefits of family pension in terms of Rule 143 of the Pension Rules of 1969. We also provide that in the event any such other persons who are entitled to the benefits of the family pension, in terms of Rule 143 of the Family Pension Rules of 1969, including the second or further wives, in a case where the parties are governed by the Mohammedan law, are not appropriately maintained by the eldest of the surviving widow or wife to whom the pension would be paid, the remedy thereof would be to make a claim for maintenance in the appropriate forum under the law, and not a claim for a payment of the family pension by the state authorities directly to such persons. But this is the law laid down by the full bench. Well, if there is a claim for maintenance, and if it comes to light that the person who is receiving the pension is not maintaining the beneficiaries properly, there can be a claim, but that claim can be adjudicated by an appropriate forum, not by this honorable court under the writ jurisdiction. But under the writ jurisdiction, mandamus can be issued to do something which is there in the rules. But if I may take your lordship to the rules of 1969,
Yes.
The definition of family, this amendment, page 158.
Hmm?
Page 158. But the following provisions are included in the rule 143.1, your lordship has got, and 2 of the Assam Services Rule 1969 in line with the All India Services Rule 1958. For the purpose of this rule, family shall include the following relatives of a government employee, apart from the relatives indicated from A to D. A to D of the earlier rule, 1969 rule, there were mention of wife in the case of a male officer A, B, husband in the case of a female officer, C, minor sons, and D, unmarried minor daughters. Thereafter, it continued. Then E, father, F, mother, G, eldest surviving brother up to the age of 18 years, H, eldest surviving sister up to the age of 21, or marriage, whichever is earlier. But then in the next page, 159, Roman 2, the pension will be admissible. Your lordship has got. In the case of a widower up to the date of his death or remarriage, whichever is earlier. In the case of a minor son, until he attains the age of 18 years. In the case of an unmarried daughter, until she attains the age of 21 years or marriage, whichever is earlier. Provided that family pension shall be allowed to continue beyond 21 years of age to an unmarried dependent daughter of a government servant, pensioner, subject to the fulfillment of the following conditions. And these conditions are not necessary. The note 1 is important. In cases where there are 2 or more widows, pension will be payable to the eldest surviving widow. On her death, it will be payable to the next surviving widow, if any. The term eldest would mean seniority with reference to the date of marriage. The applicant here is the eldest surviving widow. There is no dispute. So she is entitled to receive the pension. The question of maintaining the other beneficiary would come only when she receives the pension. But this writ petition, in fact, is a premature writ petition.
What is there in the writ petition?
But in the writ petition, she simply claimed pension for her minor daughter.
By the second wife?
By the second wife. If I may take your lordship to the prayer straight away.
Then we can dispose of the whole thing.
Yes, my lord.
Are you ready?
In the writ petition, no affidavit has been filed, my lord.
This can be treated as an affidavit.
But yes, this can be treated as, and this is a question of law. There is no question of fact, my lord. The fact this honorable court may not decide. And when there is a question of law, the Supreme Court is very clear that the court has to can issue mandamus when it is supported by law. Well, there are judgments of 1971 and other judgments also which says the same thing.
What do you say?
But in the Supreme Court decision, Rameshwar Devi, well, it is stated that the minor son and daughter entitled.
There will be the eldest surviving wife will act as a trustee.
Yes.
Trustee. And
Yes.
he has the duty to provide the share of the
That is not done. Then you can claim for maintenance.
He already received the GPF money, my lord. No.
Well,
money
GPS
has
is a
been
different
provided,
thing.
my lord.
Under Rule 136 of the
pensionary
Pension Rule
benefits,
1969, she was named as a nominee. For GPF, he has a separate claim. But so far as the writ petition is concerned, it is for pension.
It is a pensionary
But
benefit.
for pensionary benefits, there is no gainsaying the fact that the eldest surviving widow will receive the pension. If she doesn't maintain, then the question will come for maintenance.
1 minute.
And receive page 35, my lord. He received the, my lord, entire GPF money, 9,34,000.
Whatever it is.
Yes,
Are the state respondents filing affidavit? Not required.
No, but if this is a private dispute, let them sort it out, so we'll pay.
Then we'll hear the whole thing.
Yes. But till then, my lord, the order may be vacated so that the pension process may be initiated. But none of us will be benefited if it is kept pending.
I'm giving a short date. I'm not giving a-
Well, it is the 4th time, well, it is listed. Earlier occasion also, well, there is a direction to dispose of the matter, whole matter. Well, your lordship may peruse the earlier orders. Well, it's a question of pure question of law. My lord, if the order is vacated and let the read petition be kept pending, I have no objection. But let the process be started. At least I receive the pension. Then only I will pay to the beneficiaries of the second wife. Unless and until I receive a pension, which is pending since 2013.
Okay, heard, Mr.
As Biswas.
Yes, Biswas, learned counsel for the applicant. Also heard Mr. Kia Bhatkari, learned counsel for the opposite party number
1.
one.
Petitioner.
And Mr. Read petitioner and
Respond number 2, Lordship.
Mr.
CKS Borwa.
CKS Bara for the opposite party number 2.
No, it is not against it. In the IA Lordship, I am respond number 3.
Opposite party number.
Opposite party number 3 in the IA Lordship.
How about the others? All are state.
Technical.
Lordship, I am appearing for 8 in this, in the IA Lordship.
2.
P. Nayak,
Technical.
counsel, correspondent 8.
Finance 4. 4 and 8.
My lord, I am appearing for
CKS you have 4?
for 3 Lordship, pension and public records.
Technical. 2.
I'm appearing for respondent number
2.
5. 2, 5 and 7.
P. Nayak, no, not P. Nayak, but 8 Chandra. Or it will be 4 and 8, I think. And your good time, please, MS? G. Bora. Then government advocate. Standing counsel agriculture for respondents. 2,
5,
and 7.
5 and
I.
Okay. After hearing the parties at length, this court is of the considered opinion that it would be in the interest of justice that the amended petition be disposed of at an early date. Stop. And the present IA may be treated as a counter affidavit in the amended petition. Stop. Accordingly, this matters. Give a short date.
Well, the Friday, this Friday. Well, I am 75 years old lady, my lord. When I will die, I also don't know, my lord.
19th? 19th? No adjournment.
No.
On 19th.
Then it may be fixed in admission then.
In the admission column.
My lord, I am appearing for respondent number 6 in the read petition, my accountant general.
So and so for
B. Rava.
B. Rava for respondents.
But can it be on 15, my lord? 19.
15, there will be some difficulty for the court.
16, my lord.
15 and 16, some difficulties.
All right. Item 53.
May it please your lordship.
Why is it coming for orders?
Lordship, notice was issued on the last date and the other side also entered appearance. Maybe it is wrongly listed in the orders today, Lord.
Is there any private respondent?
No, your lordship. In fact, lordship, this is no private respondent. Covered matter, lordship.
Who appears for union?
If the council was there some time back, I don't know where she is now. Lordship, in fact, it is a covered case and we have annexed a similar judgment, lordship, page 84.
Yes, you Saikia?
Lordship, I'm on behalf of U Saikia, Z Islam.
What Z Islam, Learned Counsel appearing on behalf of Mr. U Saikia, Learned Counsel for the petitioner. None appears for the respondents. List the matter in the admission column.
Lordship.
After 2 weeks.
Lordship. Obliger.
54. May I please your lordship.
No, instruction is awaited, my lord. Instruction is awaited, my lord.
Why is it coming for orders?
Orders, it should have come in the admission column.
Admission column, lordship. Lordship, matter is non-payment of the salary, lordship, but
Non-payment of
arrear and current salary, lordship. In the meantime, lordship, kindly current salary may be paid, lordship.
Otherwise, petitioner have no other income source, lordship. It is very difficult to maintain his self and family also, lordship. My salary was withheld, lordship, on the basis of non-existing fact, lordship. Lordship,
We'll post in the next week when I get the full instruction.
lordship, in FIR, lordship, 7 person also there, lordship. And charge sheet also filed, lordship, but my name is not charge sheeted, lordship.
Okay.
And lordship, in court below orders, lordship, no cognizance is taken against me, lordship. And lordship, SP also, Honorable Superintendent of Police also issued a certificate, lordship. There is no criminal antecedent against me, lordship. Despite those facts, lordship, the respondent authority is not paying the arrear and current salary to me, lordship.
That part you'll have to.
Lordship will get it after a week, in the meantime, and get the instruction. There is an order that they will pass on 15th November by the salary.
Your good name, please.
Alim SK, lordship.
But Mr. A. Alim SK.
And my humble prayer before your lordship, kindly, current salary may be given, lordship.
1 minute. Mr. S. Bora.
Lordship, I am for the PTC authority.
Learned Standing Council BTC. Twice for a week's time to enable him to receive instructions. Stop. Praise aloud. List on. When do you want?
Let it be on 16th, Lord.
16, there will be some difficulty. 21st?
Lord.
21st in the admission column.
Problem.